We'll take it up on 5th August.
If just say a bit କରିବାକୁ proceeding କରିଯାଉଛନ୍ତି
ତାହେଲେ ସୋମବାର ଦିନ supplementary list
yes
High matter I challenge legal hair certificate. Legal hair certificate ମୋ ପାଖରେ ନୁହଁ। ହଁ other miscellaneous certificate, star certificate and other certificate ମୋ ପାଖରେ certificate ତ ଅଛି other welfare schemes of the government but not certificates ସେଟା ବୋଧେ କୋର୍ଟ ନମ୍ବର 10 with Justice Patnaik ଆପଣ ପାଖରେ ଅଛି ଆମର ନାହିଁ Mr. Rao, check up with the other schemes of the government.
Pardon to mention, my lord, item 22 of Passover weekly list, my lord.
Yes.
On behalf of Senior Counsel Mr. SP Mishra, I pay for 1 week time, my lord. He is not well, actually.
All right. Let's this matter. Do we commencing? 12th August.
Great.
Pardon, my lord, item 18, lords.
Item?
18. Today
Of which list?
Today list, supplementary list.
Supplementary, yes.
Infructuous.
Item 18 dismissed as infructuous.
Obliged.
Yes. Transfer matter.
Yes.
Transfer matter.
No.
There are two items, both the items. In item number 18,
there are two items. Both will be disposed. All right.
Supplementary list, item number 1 for judgment.
In the result, the appeal succeeds and is therefore allowed. The judgment and decree passed by the first appellate court is hereby set aside, and that of the trial court is confirmed with the modification as indicated in para 16 of this judgment. There shall be no order as to costs.
Item number 2 for judgment.
The above stand of the government has not been denied or disputed by the petitioners. Be that as it may, the petitioners claim for grant of selection grade scale of pay. The petitioner's claim for grant of selection grade scale of pay has not been rejected by passing specific orders so far. It is therefore left to the authorities to take a call in this regard in accordance with law. This court would hasten to observe that if the petitioner is otherwise found eligible to get selection grade scale of pay, the same shall be effective from 10/8/2001, that is after 8 years of service in the senior lecturer scale. The writ petition is therefore disposed of in terms of the above observations. You have not denied his selection grade. The date is only a little bit, it has to be.
Item number 3 for judgment.
Second appeal. Resultantly, the appeal fails and is therefore dismissed, but in the circumstances without any cost.
Item number 4 for judgment.
Resultantly, the writ application is allowed. The impugned advertisement dated 28/4/2017 is hereby quashed. The concerned authorities are directed to take the selection process held pursuant to the advertisement dated 15/12/2015 to its logical conclusion by issuing necessary order of engagement in favor of the petitioner without any further delay, and in any case not later than 2 months from the date of production of certified copy of this order.
Item number 5 for judgment.
Bad news for you. For the foregoing reasons, therefore, this court finds that both the collector as well as the appellate authority have rightly found the petitioner guilty of misappropriation, and for which this court is not inclined to interfere with the impugned order. Resultantly, the writ application being found to be devoid of merit is therefore dismissed. There shall be no order as to case.
Item number 6.
Sometimes good, sometimes bad.
Yeah. Item 6, pursuant to your lordship direction, the ADM is present.
Yes.
With the affidavit.
And what about the file?
File he has got.
He has got the file?
Yes.
So what is the explanation? Let me see for non-compliance of this order.
From paragraph 3.
Was there communal tension in Balesur municipality?
Yes, yes. That was. Recently, it has been withdrawn, the curfew.
This is absolutely not acceptable. Absolutely not acceptable.
No, these are the facts.
No, you see, he writes, he admits that I've been working as additional district magistrate Balasore since 21/6/2023. A subtle hint that I was not aware of the previous order anyway. He says that a letter number HA 72/2023 has been received in Balasore Collectorate before my joining as ADM Balasore. Unfortunately, this letter has not been brought to my notice. Who will believe it?
No, that is a fact in the sense the collector marked it to the
No,
DSWO.
no. The subsequent letter was marked to the
Yes,
district social welfare office.
DSWO.
Subsequent letter.
Yes.
What happened to this letter? He doesn't say anything.
The first letter, though, was received prior to his joining, but it was not brought, unfortunately, it was not brought to his notice.
It means he has no control over his office, isn't it?
That of,
Any letter can be filed from the Advocate General, from the office of the Advocate General, but it will be ignored by the concerned clerk. He will decide whether to bring it to the notice of the
that
ADM
should
or
not
not.
have happened, yes.
And then he writes about, he says something that with a child development project officer Jaleshwar with a request to proceed to the office of the Advocate General to Odisha to discuss,
Yes,
along with the Anganwadi appeal number also to discuss. But due to ill health, the CDPO Jaleshwar could not dispatch the appeal case record promptly. Should I call for the medical report from of that CDPO for that period?
my usual submission would be, my lord, since
No, I would like to, you know me, I would like to keep them, set the matter at rest, but anything that
In
goes
fact-
against the dignity of this court, I am the last man to tolerate.
no, that should not. Yes,
And then he says about that communal tension, then about the experimental flight trial of the ITR.
those are the facts that he has stated.
What is this? All these things has, resulted in ignoring the orders of this court.
It cannot be said that
This,
ignoring.
this
but,
should have been taken, this should have occupied top priority.
Yes,
When
Yeah.
for 1.5 years, the matter, this court has been passing orders. Where has he submitted any unconditional apology?
yes, yes.
Yes, you are Mr. Sudhakar Naik. You are a senior officer, a pretty senior officer. So how you have absolutely no control over your office, it seems. The orders, repeated orders being passed by the High Court are being ignored, and you are coming up with excuses. You are one after the other, you have just given excuses. You know this can be contemptuous. Then has the original file been produced?
Pardon me?
Has the file been produced?
Yes.
The original file? Yes. Give it to the State Council. Sri Sudhakar Naik, working as additional district magistrate Balasore, is present in court pursuant to the previous order. He produces the original case record relating to Anganwadi appeal number 3 of 2018. Further, he submits a compliance affidavit. He has filed a compliance affidavit explaining as to why the order passed by this court repeatedly, the orders passed by this court repeatedly were not complied with earlier. Stop. After perusing the affidavit, this court does not find the same to be satisfactory. However, taking note of the fact that the order has ultimately been complied with by production of the concerned file, the affidavit is accepted. With affidavit is accepted, Sri Naik is warned to be more careful in future and to display due diligence and promptitude in complying with the directions of this court, directions that may be issued by this court. Yes.
Personal appearance.
देखिए. If it is necessary. What is it?
Yes, Lordship.
What was the matter, please?
Matter, Lordship, kindly annex to page 15, Lordship.
Yes.
This
In
is
the advertisement.
This is the advertisement, Lordship. By the ICT, Jaleshwar ICTS project, with respect of the Vishwanathpur Mini Anganwadi Center. The last date of application, the fourth line of the first para is 8/5/2017, Lordship. The Anganwadi Center is, Lordship, will find on page 21, serial number 17.
Yes, Vishwanathpur.
Vishwanathpur Anganwadi Kendra.
Mini
Mini
Anganwadi.
Anganwadi Kendra, Lordship kindly see the service area.
Sampurna Vid-
संपूर्ण विश्वनाथपुर पोड़ा ग्राम को नहीं सीमा निर्धारण करा जाए एंटर विश्वनाथपुर इज कम देन लॉर्डशिप काइंडली सी द अगेन पेज 15 द को फर्स्ट पैराग्राफ लॉर्डशिप प्रार्थी केवल अंगनवाड़ी केंद्र परिक्षुप्त ग्राम साई पोड़ा सर्विस एरिया अंचल स्थायी बासिंदा होइथिबे सेथिपाई स्थायी बासिंदार बासिंदार प्रमाणपत्र दरखास्त संलग्न करा जिवो केंद्र अंचल परिक्षुप्त बासिंदा बोली सर्विस एरिया मध्य दरखास्तकारी स्थायी बासिंदार प्रमाण कराइबा सत्यपाठ टू मैंडेटरी इज रिक्वायर्ड वन इज रेसिडेंट सर्टिफिकेट
And affidavit.
affidavit then lordship I applied for page 22
Page
page 22
22. Yes.
this is my application
Yes.
I applied in my matrimonial house lordship kindly see the village is Vishwanathpur this is the service area
Hmm.
and this application was appended with lordship kindly see the page 23 this is the receipt receipt lordship kindly see page serial number 6 and serial number 9 the resident certificate and the affidavit also then lordship kindly see the affidavit part page 26 lordship page 28
Yes.
I Bhavani Rani Mahanta present petitioner wife of Shatrughan Mahanta village Vishwanathpur post Chudamanipur Raibonia that I am the deponent of this affidavit I am permanently residing village Vishwanathpur post such and such lordship there I am applied for a post of sub Anganwadi worker of Vishwanathpur Anganwadi center number such and survey number khata number such and the Anganwadi center is 100-meter distance from my house this was also again come to the page 22 my service area was inquired by the three persons lordship kindly see page 22 last Bhavani Rani Mahanta Swami Shatrughan Mahanta Anganwadi Kendra Anchalar Basinda Atanti this is the LS lady supervisor signed this is the CDPO this is dated 10/5/2017 and this is Anganwadi worker means the mother Anganwadi worker Rautrai then lordship kindly see the resident certificate lordship resident certificate page 26 26
Yes.
this is the first resident certificate I have appended along with my application Miss Bhavani Rani Mahanta daughter of Sri Tarindra Mahanta is a native of district village Bhaleswar in the state Odisha and she ordinarily resides in village town Vishwanathpur that is the service area PS Raibonia such and such then lordship kindly see page 30
Tiris.
yes lordship this is the comparative sheet of the three candidates who have applied for the post of Anganwadi worker my serial number is 2 this is lordship I have secured 49.5 marks HSC marks the serial number 3 is the opposite party who has been got appointed she secured 36.66 marks and against this column serial number 2 the remarks is resident certificate not submitted in time of verification then lordship kindly see for a moment the appellate court orders what is the CDPO's case before the appellate authority page 13 lordship kindly see first paragraph
Yes.
the respondent to CDPO Jaleswara stated that the appellant Srimati Bhavani Mahanta being a married lady had submitted her residential certificate obtained in the name of her father with application which was revealed during the scrutiny of applications on 9/5/2017 as she had failed to submit the said residential certificate in the address of her husband by the date of scrutiny on 9/5/2017 selection committee had cancelled her application due to non-submission of the required genuine residential certificate lordship what I have done lordship the resident certificate I have submitted along with my application that will lordship kindly see page 26 though the service area is there my parental house my matrimonial house is within the same tahsil of Jaleshwar Tahsil but the tahsildar did the tahsildar instead of my husband's name she issued the certificate in my father's name that is the reason my application was not accepted by the authority now lordship the guideline the purpose of mini guideline lordship kindly see
Achha, achha, bhai, achha. Page
Page Lordship 49. 48
49.
starts.
40?
48.
Yes.
The relevant portion is 49 first, Roman I.
Hmm.
The required means that the candidate shall be residing in the service area of that particular mini Anganwadi center. That is the relevant portion. So I am only placing that.
कोई जगह पढ़ते
Lordship, the page 49 first.
The candidate shall be residing in the service area of that particular mini Anganwadi center.
Mini Anganwadi center.
Yes.
The guideline shows this requirement and so also the advertisement also shows it. Nowhere the guideline or advertisement mandates that in case of a married lady, the certificate must be produced in the name of the father, not in the name of the husband. Particularly when I have never applied my indicating the address of my parental house, though coincidental my parent house is within the same tahsil. I have entirely applied my husband's residence, but the certificate issued in my name of my father. Lordship, thereafter, for the abandoned question, Lordship, I have submitted also the second certificate, Lordship, analysis. Second certificate will Lordship will find at page 32.
Yes. I've seen it.
This is also the address system, but this time the Tahsildar changed by husband's name. Nowhere this first certificate, the second certificate, and the address form. I have never given the address form of my parental house, nor the parental house is coming within the service area of the Anganwadi center. The parents' house is not coming under the service area of the house. But the legal point you Lordship kindly consider. I am a meritorious student seeking 49% marks. The advertisement, so also the guideline does not require that in case of a married lady, that the certificate must be produced in the name of the husband's name. Nor the miscellaneous certificates rules, there is nowhere prohibits that the certificate cannot be issued in name of the father in case she is married. Certificate is permissible as per the miscellaneous certificate rules, both in the father and the husband. So for that reason, Lordship, what my submission is, the appellate court says that the second certificate was filed after the cutoff date. That is the 9/5/2017. What my submission is, Lordship, the first certificate cannot be invalid in the eye of law, and so are also the mandates of the advertisement and the guideline.
Okay.
That should be my
Why was this file called for?
file call for Lordship. The region they have page 30 when the first time 1 year before I argued before Lordship, the page 30 they have region stated that the resident certificate not submitted at the
I know verification.
but the appellate court they have said that we have rejected. Appellate courts the case before the appellate authorities case CDPO's case that we have rejected that application due to the resident certificate is submitted in name of the father. That is only legal point your Lordship will consider whether my first certificate is valid or not. And that to the same authority and the joint committee, joint inquiry was conducted. Same authority also found my in the next day, 9th was the last date, on 10th inquiry was conducted.
Just. श्रीमती मामिनी हाजदा दस्ताकरणी नवम श्रेणी पास करछन जाके ई पदवी में उपयुक्त अटंती द्वितीय दरखास्तकरणी भवानी रानी महंत उनकर बासस्थान प्रमाण पत्र निज पितांकर प्रदान करिथिले एवं जेहेतु से विवाहित अछंती तांको सासुघर सह सर्विस एरिया रे बासस्थान सर्टिफिकेट दरकार थिला जाकी से प्रदान करि नथिले एवं जांच तारीख So your father's house does not come within the service area.
No. I have not given the address of my father's house in application. I have
So
given-
that application has to be seen. Why will he issue that certificate in the name of your father unless you give your address stating it to be care of your father?
that is the mistake because both the address, both the revenue records of my parental house and the matrimonial house is coming with the same tahsil. That is a mistake, Lordship. If I have applied for the address of my husband's house, How can I apply name of my parents? Even parental house is not coming under the jurisdiction of service area. Why should I apply lordship? Because there is a mistake done by the consultant.
We have also submitted before the application that both father house and husband's house in same village Vishwanathpur at page 11.
Page 11.
Yes. Page 11 of the order, appellate court order, appellate
Same.
parental house and her father-in-law's house.
So there are two certificates were produced. Originally, the certificate showing
Same village, their father's house is in village Chudamanipur, which is different village and separate to Vishwanathpur.
Yes.
And she applied in the name of her father. So RI inquired that her father's house is at village Chudamanipur. I have filed the document, the admission register of the respondent number, petitioner, in which it has been mentioned that
no, there are
Bhavani Rani Mahanta, daughter of
there are two things, sir. First, do you dispute that she is married? They say you don't dispute that.
no man.
Secondly, is it your case that despite marriage she is residing with her father? Because the Tahsildar has also issued a second certificate.
Second certificate is not acceptable as per the decision of this honorable court and basing on the decision of the appellate.
Second certificate is not acceptable where the residence area is changed. But here there is a correction.
Correction.
This is just a correction.
When she applied in the name of her father, it is the duty of the RI.
I have never
Find
applied
out.
in the name of my father.
No, we will call for that record. We will call for that
I
record.
have never applied in the name of my father.
What do you
Kindly
say?
see my application.
Huh? Let him produce that miscellaneous certificate rule file. We
Yes.
find out what was the application.
Yes, yes, yes. That is online application.
So that is it is to be produced by the sub collector, not Tahsildar. So he will do it. He will collect it from the Tahsildar and produce it. Yes. তারপরে further তা পূর্ব যদি accepted লেখা আছে তা পূর্ব লেখନ୍ତୁ nevertheless Sri Naik has begged unconditional apology for the lapse তারপর লিখে accepted এখন তাই লিখে in course of hearing Sri Parijal and counsel for the petitioner forcefully argues that his client had never applied for the residential certificate showing her father's address. As such, she again submitted an application for correction of the certificate, which being corrected, a new certificate was issued showing the name of her husband. Stop. Sri Mahathir and counsel for the petitioner seriously opposes this contention by submitting that the petitioner had willfully applied for residence certificate showing her father's address, which was duly inquired by the RI, and accordingly the certificate was issued. Stop. He further submits the the paternal house of the petitioner is at a different village.
It's Chudamanipur.
Under
In
the
Chudamanipur.
on the same Tahsil.
Stop.
Yes.
Jalasur Tahsil.
And my submission is after cut-off date, second certificate.
That is your main that is your main. In order to appreciate the contentions, in order to appreciate the rival contentions, it becomes necessary to peruse the file relating to is the number লেখা নেই miscellaneous certificate case number লেখা নেই anyway the file in which file of the Tahsildar Jaleswar in which the application for grant of residence certificate of the petitioner was dealt with.
Yes.
The ADM Baleswar who is present in the court shall obtain the file from the Tahsildar and produce the same before this court on the next date. Yes? Please this matter.
Issued on 20th
See, ଗୋଟେ file ତ ତାଙ୍କ ନାଁରେ file ରେ ତ ସବୁ ଥିବ।
ସେକେଣ୍ଡ ଗୋଟା ଫାଷ୍ଟ ଗୋଟା ତ
ସେପାରେଟ ହାଇ ସେପାରେଟ ମିସଲେନିୟସ୍ ଆପେଲେଟ୍ ମାନେ ଗୋଟେ ଯୋଉ ଓଡିଶା ମିସଲେନିୟସ୍ ସାର୍ଟିଫିକେଟ ରୁଲ୍ସ ରେ ଗୋଟିଏ ନିଷ୍କେଷ ତ ହବ ନା ଦିଟା ତ କେବେ ହବନି କରେକ୍ସନ ପାଇଁ ସେ ଫାଇଲ ଆସିଲେ ତାକୁ ଜଣା ପଡିଯିବ
ଆଜ୍ଞା
ଲିଷ୍ଟ ଦିସ୍ ମ୍ୟାଟର ଅନ୍
9th August.
9th August. Yes. The ADM shall remain present in the court with the files. Yes. Yes.
Item number 7.
10th ହବ
10th. Okay.
10th ହବ
ଅଛି ବହୁତ ଓ ଶନିବାର ସେଟା ଆଉ ନାଉ 9th ଆଉ
12th
16th.
16th August को देना।
16th August.
16th.
Yes.
Item number 7.
The appeal records will not be before.
Appeal record thou. The appeal record be kept on record. The record produced by the ADM should be kept on record. Yes.
Item number 7.
Husband's
The
application.
personal attendance of Sri Naik be dispensed with for the time being.
But he has to come on
No, that I have already passed that order.
Yes.
Yes.
on 16th.
Yes, Ms. Mapan.
Here, my lord, the husband's application for transfer of the 125 proceeding to Puri from Nayagarh, my lord.
Yes.
Because of the fact, my lord, divorce proceeding is pending in the Puri before the Learning Judge Family Court Puri. And she has also appeared in the proceeding. I have given the order sheet.
All right, issue notice to the opposite party by speed post. Returnable, with fixing a short returnable date, requisites be filed by Monday peremptorily, list this matter on
6th September.
6th September. I hear adjournment korbo. Yes.
Item number 8.
Yeah, please, Your Lordship. But the wife has preferred this application to transfer the matrimonial proceeding of a divorce case filed by the husband from the court of Judge of Family Court Jagatsinghpur to Judge of Family Court Cuttack.
Notice adjournment.
Well, in the meantime, 4 dates, last occasion Your Lordship directed the party should first participate in counseling proceeding. In the meantime, 4 dates have elapsed.
This is not for the first time it has come.
Yes, my lord. But first, on dated 16/2/2024, this court observed that
What happened to the conciliation?
in the meantime, 4 dates have gone, but the husband has not cooperated, not on now.
Let notice go. Let notice go. Yes.
My lord, the interim order to
So I told adjournment upon.
he has to go, she has to go there and disabled son is reading
okay,
their
sir.
matter.
Yes.
Item number 9.
From the transfer of CP case from Family Court Jaipur to the Learned Family Court Malkan in last occasion IA was not there, that my lordship adjourn this matter.
Yes, yes.
Last occasion IA was not there, that my lordship will adjourn this matter to this week.
Correct.
Yes,
Notice and adjournment.
IA,
I hear adjournment.
so IA has,
Item number
no,
10.
IA adjournment, last occasion IA was not in the file.
Item 10.
From Family Court Jajpur to the Family Court Bhubaneswar to Family Court Jajpur Lordship. On the ground that the petitioner being a lady is the wife and
Notice. Notice how adjournment. Yes.
Item number 11.
Please, Your Lordship. Here, my lord, the petitioner has been continuing as Gram Rozgar Sevak since the year 2008. And during the year 2024, the government in the Panchayat Raj department issued a notification for regulation of the Gram Rozgar Sevaks.
I think it is covered.
WPC number 5838 of 2024.
Covered by that judgment.
Annexure 5, the repentation is pending.
Have you seen that? Have you seen that judgment? Let him go through that judgment.
May I permit?
Yes, yes.
He has also filed an additional affidavit indicating the fact that, my lord, already in the meantime.
That office order was issued. Yes.
No, ସେମାନେ already observe ହେଇଗଲେଣି ବୋଲି.
Others have been observed.
Others have been observed. And to that effect, he has already made a representation at annexure 5.
Yes.
May I pray, my lord? I can share the number to him, my lord. that is WPC number 5838 of 2024, disposed of on 9/7/2024. Authority may be directed to consider the same in the
Yes,
light
I-
of the.
In light of that judgment?
Yes, sir.
You have not gone through that judgment?
I will go through your lordship and direct. Order. That's all.
କଣ ମୁଁ ଜଜମେଣ୍ଟ ଦେଇଛି ଆପଣ ଜାଣିନାହାନ୍ତି, ଆପଣଙ୍କ ଫେଭରରେ ହବ ନ ହବ ଯଦି
I got it, senior sir.
କାଳେ ଆପଣଙ୍କୁ ଏଗେଷ୍ଟ ଯଦି ଯାଉଥିବ।
ଜୀବନ କେବେ ଯିବ?
ଆପଣ ଦେଖିନାହାନ୍ତି ଜଜମେଣ୍ଟ, ସାପ ଅଛି ବେଙ୍ଗ ଅଛି କଣ ଅଛି ଆପଣ ଜାଣିନାହାନ୍ତି, ଆପଣ
Annex 5 is
ପାସ୍ ଓଭର କରୁଛି ଜଜମେଣ୍ଟ ମଗେଇକି ଦେଖନ୍ତୁ। I will pass that order, go through that judgment.
Yes, ma'am.
So
Only due to pendency of vigilance case.
I have dealt with,
my case-
specifically dealt with that matter.
Yes.
So
Your lordship and direct. I will.
all right. The petitioner's grievance is that despite being eligible for absorption as accountant cum data entry operator on regular basis, his case has not been considered, apparently on the ground of pendency of a vigilance case against him. In course of hearing, it is stated at the bar that similar matter was dealt with by this court in the case of
WPC 5838 of 2024. madam.
WPC
5838 of 2024.
5838 of 2024.
Disposed of on 9/7/2024.
Disposed of on 9/7/2024. Only it is stated at the bar that and necessary directions were issued to the authorities, yes, to consider the case of a similarly placed person. Stop. This court finds that the petitioner has already approached the collector by submitting a representation on 19/6/2024, which appears to be still pending. Stop. Since it is for the concerned authority to take a decision in this regard, the writ application is disposed of, directing the collector Puri to consider the pending representation of the petitioner in accordance with law, as also in light of the judgment of this court in the case of so and so, Supra, copy of which shall be, certified copy of which shall be produced by the petitioner before the collector within a week. Stop. The representation shall be disposed of finally within 2 weeks thereafter. Yes.
Item number 12.
So far it has not been challenged, Mr. Patnaik.
ଖାଲି ଗୋଟିଏ ଜିନିଷରେ ଥିଲା ଯେ ସେଠି because the post for consideration is actually accountant cum data entry operator, which is nowhere related to GRS, whether it is of assignment or.
Yes.
So, jehetu it is not a matter relating to GRS.
Yes.
And not with respect to the service condition of GRS, but it is for the filling of the post of the accountant cum data entry operator. So whether it will amount to beyond the assignment, question
No, because this is a grievance of the GRS.
Yes, sir.
Consideration of GRS for further year.
But for absorption in another post, which is a civil post.
Yeah, let it.
Oh,
Yeah, I see. Yes.
Item 12.
In this case, I am challenging the order of the commissioners.
Melody, in this
But-
case,
You will also directed to
Yes.
open instruction. That is the
often
fact.
instruction for me, my lord. When we have divided the physically handicapped vacancies in different streams. So what is the basis on which, my lord, we have actually done so? Because that is what we have stated in our para number 12 of the counter. And while replying to the rejoinder submitted by the petitioner, the additional affidavit also, my lord, we have stated so that the same procedure has been adopted in other districts also. But the instruction, the information which I have received, my lord, I just need only 1 week time, my lord, to reconcile the same with the provisions, my lord.
No, because I said that this court would like to know as to how the vacancy was filled up without being carried forward to the next advertisement. Next advertisement, you are not showing any vacancy. In the earlier advertisement, there was one vacancy. Where, how did it get filled up?
Dusmita Saman case matter.
Madhusmita San. The order dated 2/7/2024.
ମୁଁ ବୋଧେ 14/5 ଟା ଉପରେ ରହିଯାଇଛି।
No. ଏଥିରେ ଅଛି
14/5 ରେ actually
ଦେଖନ୍ତୁ it is brought to the notice of the court that pursuant to a query posed by the Director of Secondary Education, the District Education Officer furnished the category wise PH vacancy position of contract teacher for advertisement in 2013. It is seen that there was one vacancy under which category of TGT Arts. The category wise position for advertisement in November 2014, however, does not show any vacancy under this category. So where did the vacancy go?
then in the case, I have committed a mistake from my side.
Without being carried forward.
My letters.
Either it should have been filled up.
Yes.
So then you have to reconcile this.
ମୁଁ ଏଠି ଅର୍ଡରରେ ଲେଖିଦେଇଛି ଯେ 14/5/2000.
No, you take a copy of this order and comply with it.
This matter will be taken up next week, madam.
Yes. Leonard, a free copy of the order dated 2/7/2024.
I can download it.
All right.
So
Leonard,
not uploaded.
upload him.
खाली adjournment. Showing that only adjournment.
Sorry? Kimdi? Upload kahin hum? A free copy of order dated 2/7/2024 be supplied to the State Council for compliance. Please this matter.
2nd August.
On 2nd August.
Item number 13.
Merits.
Well, I'm already objection filed on today. This petition filed
In order dated 19/7/2024, in paragraph paragraph 2 be substituted as follows. Learned counsel for the petitioner files an application for amendment, copy of which has been served on the other side in the court today. Hello? Yes.
I filed objection, my lord.
Learned counsel for the opposite party files objection to the petition for amendment. After serving copy on the other side, the same be kept on record. Yes.
Copy already served, my lord.
Yes.
Copy already served.
Yes. What amendment do you want? You want to challenge the RDC's order?
Yes, ma'am. Already I have got to make this party, your lordship category denied on the last occasion. For that reason, only my amendment is the order of the RDC ma'am, in the prayer portion. Only.
In the contents of the petition, they have mentioned in the categorical, they have mentioned an application filed under Order 27A of Chapter 4 of Orissa High Court rules read with 110 of the CPC for amendment.
That is not accepted. That I am not accepting. I am not. But he wants to challenge the order of the inquiry report of the RDC. That
your lordship had directed to conduct the inquiry, and they have conducted the inquiry and placed the report before your lordship. Now he wants to challenge it.
He can challenge it. What is wrong in it? Yes.
I have already served a copy of the same also.
Yes. Aye.
But only thing, my lord, may I be permitted to matter. There is no, I am not disputing that for amendment of this one, my lord. But this particular prayer is not supported with any pleading.
Which one?
The present prayer.
No, that is why he wants to amend and bring necessary.
He is not bringing out any other pleading matter. He is only making a prayer, changing the prayer.
Enter petition and also completely wrong concept.
Schedule of amendment.
Pleading
no, man.
So this is an
petition is completely wrong. Enter petition is wrong.
Yes, Mr. Pratap.
Enter petition.
You have simply asked for. ठीक है, automatic होना चाहिए. ठीक है, wait करो तो. Why interrupting? I don't understand. Sir, you are only you want to amend your prayer portion. So you have to show, you have to bring in pleadings to, if you are challenging the order of the RDC or the inquiry report of the RDC, you must show, you must plead how it is wrong. Only simply by the prayer on the basis of oral submissions, it cannot be done. This is a High Court after all. The only evidence is the affidavit evidence.
ମୁଁ ସେଟା consolidated petition ରେ ସେ predict ନେଇଯାଇଛି।
So ଏଥିରେ ନାହିଁ ଯେ schedule ଟା ଆପଣ ଲେଖିନାହାନ୍ତି ଆଇଏରେ ଲେଖିନାହାନ୍ତି କେମିତି ହବ?
consolidated petition ରେ ନେଇଯାଇଛି।
କାହିଁକି ଆପଣ ଏମିତି କରୁଛନ୍ତି? ଭୁଲ ହବ। Only the prayer. Rather not press it and file another application. Taking specific pleadings, why you want to challenge them? You have to bring in pleadings. Whether it will be accepted by the court or not is a different matter. But at this stage, Leonard Sri Pratap, Leonard Counsel of the petitioner, submits that the IA be not pressed and liberty be granted to him to file a better application. Permission is granted. Let's this matter. Next week record. Let's this matter next week. Better application, if any, be filed in the meantime. You have to bring in those pleadings.
Yes. मतलब consolidated petition ନେଇଯାଇଥିଲି।
ନା ସେମିତି କିନ୍ତୁ amendment allow ନ ହେଇକି ଅଲଗା ପ୍ରକାର ଆପଣ ନେଇଯିବେ ସେମିତି ହବନି।
Item number 14.
Lordship wanted to, my lord, case, my lord. Lordship will find that record has also come, my lord.
The Rusi case Bindani?
Yes. 11748 of 2008. No, 2003. I'm sorry. My lord, there what has happened, my lord? An advertisement was issued in the month of March 2003, my lord. My lord, for recruitment of Swechhasevi Shiksha Sahayaks, my lord. My lord, subsequently, the my lord, a notification was issued to recruit further 15,682 numbers of Swechhasevi Shiksha Sahayak without complying the my lord, requirement of the guideline for which it has been passed, and the direction has been issued to conduct a fresh recruitment in relation to those lord, filling up those posts, my lord. Subsequent to that, my lord, another notification was made. What has happened, my lord, in my case, my lord, this in our case, but this is the andrometric.
Yes, yes.
Yes. My lord, this judgment in my humble submission, my lord, that this will be no way helpful for the purpose of adjudication of the present case, my lord, because here, my lord, in terms of that, my lord, subsequent advertisement which was issued in September 2003, my lord, I applied. My lord, I was selected.
I'll cut short.
Yes.
The very short point is that,
yes,
if I remember correctly, without opening the file also, he had appeared in the matriculation examination in 1988.
Yes, ma'am.
Prior to that cut-off date.
Prior to cut-off date, he had appeared.
Yes.
He failed. Subsequently, he succeeded. So, it was by way of a supplementary or compartmental? Something like that.
By way of compartmental.
Compartment. If it is by way of compartmental, will it not be treated as has been treated in case of somebody else?
Yes.
Some other person.
That I have given in my further affidavit.
That we have clarified, ma'am. May I be permitted?
Yes, please. That is the only point.
Yeah, that my before my senior starts, my lord. Just my lord, bring it to your lordship's kind notice, my lord. They have taken the stand that the subsequent notice, the other person who has got, my lord, in the same, my lord, having the same background, my lord, he has got the job because there the advertisement was issued, the qualification has been prescribed there that IA with intermediate with CT, my lord. Here in my case, that matriculation with CT. So, my lord, this is the difference for which they are saying that does not cover this. My lord, the case
principle will apply.
Yes.
It's a question of consideration of a certificate. What was the essential qualification in that case, and in this case may not be very relevant. Please.
Yes. So only shall I confine my answer to the query what your lordship?
Yes. Our kitchen, whose case Bindani doesn't apply.
No, the reason being, my lord, the case has been called for because I submitted that on the last occasion. That initially, my lord, in the year 2003, when the advertisement was issued, At that particular point of time, the petitioner is not, actually, the petitioners didn't get any appointment, my lord. Later on, my lord, as per the decision of the government dated 26th September 2003, from the waiting pool, they wanted to fill up the rest vacancies. Now, this decision of 26/9/2003 became the subject matter of adjudication in Hrishikesh Mingani case. There, my lord, the said decision of government dated 26/9/2003 has been passed. And thereafter, the engagement orders were issued after issuing a fresh advertisement. In the fresh advertisement, the case of the petitioner, my lord, has not been taken into consideration for the reason that, my lord, he didn't have that particular minimum education qualification. So, with respect to that qualification, my lord, the petitioner admits that his certificate is beyond the cut-off date. Now, he relies upon few correspondences thereafter that when a person has already appeared, but later on by way of compartmental examination or supplementary examination, if he has received the certificate after the cut-off date, whether that can be taken into consideration for the purpose of employment or not. But with respect to that, the answer is not there. However, my lord, he is relying upon another person's case. That is what, my lord, we have clarified. That when we decided to take into consideration the case of the other person, that is on the basis of another advertisement where the +2 is the minimum qualification, and taking into consideration that academic qualification issued by the Andhra University, he was allowed to prosecute his study for the +2. And the +2 certificate is not in cloud, my lord. Once that is not in cloud, and that is the minimum qualification, and we didn't have any requirement to go through the authenticity of the document of matriculation. So we considered his case, and accordingly we gave his appointment. But in this case, my lord, in the case of the present petitioners, the very basis on the basis of which, my lord, his case is to be considered, merit is to be assessed, everything is to be done on the basis of that particular certificate. And since that certificate is actually not to be taken into consideration, so placing reliance upon another person who is not completely in identical footing. So that is what, my lord, we have checked.
This court was actually, this court would like to place emphasis on the principle adopted.
Yes, ma'am.
More than the other qualifications.
Yes, ma'am.
Or other points of similarity, if at all they exist.
Yes, ma'am.
It is a question of principle. If you accept a certificate in respect of another person, why will you discriminate it against this petitioner?
My lord, the acceptance of the certificate.
Let us go to that document for a moment.
My lord,
That other person.
My lord, the other person, your lordship will find that in my further affidavit, additional affidavit I have filed, my lord.
Additional affidavit. First case, though, N. Ishwar Rao.
Annexure, your lordship may first come to this annexure 15, my lord, at page 9. My lord, this is the reply to my learned senior.
Where is it?
My lord, additional affidavit which I have filed, my lord.
Additional affidavit, yes. But there is no annexure 15 there.
Annexure 15 is there, my lord, page 9.
Additional affidavit.
I was
looking at the other file. Yes, annexure 15.
Annexure 15, this is the reply to my learned senior, because my learned senior says
the clarification was issued.
Yes.
Is it not discriminatory? My question is very simple. Because you are talking about talking of principle. You see, let us read this letter.
Yes.
With reference to this, I am to inform you that Sri N. Hemasundara Rao, junior teacher, now he completed continuous and successful service of Gala. During the regularization process, it is found that N. Hemasundara Rao was completed his matriculation from Andhra University. Before that, he had appeared the matriculation for the first time in 11/11/1988.
Yes.
It is similar to the case of the petitioner, but he was able to clear only 2 subjects out of 3.
And this gives a reply to my learned senior, my learned friend, my lord.
Later on, the 2 subjects appeared clear on 30/11/1918, and which is beyond the equivalent period. Hence, as he has cleared the back papers after admissibility of the equivalent period, it may be clarified that whether the back paper happened. यार clarification कोड देले से
तापरे clarification but subsequently they have.
so it means it was accepted or not?
What he says, my lord, that there is no requirement of going to the original qualification, that is material qualification. Then why did you issue this letter making a query to the BSc?
Here there is apparent violation of article 14. ଯଦି ଆପଣ ଜଣେ ଲୋକଙ୍କ ପାଇଁ ଆପଣ ୟୁଜ କରିପାରିଲେ ସେ ପ୍ରିନ୍ସିପଲ ଟାକୁ ସେମ୍ ଅଲମୋଷ୍ଟ ସେମ୍ ସେ ଆଗ ଆପିୟର କରିଥିଲେ ବ୍ୟାକ୍ ପେପର ହେଲା ବ୍ୟାକ୍ ପେପର ଦେଇକି ଇଏ କଲେ ମାନେ ସବୁ ବ୍ରିଲିଆଣ୍ଟ ଷ୍ଟୁଡେଣ୍ଟ ମାନେ ସବୁ ଇଟ୍ ଗୋଜ୍ ୱିଦାଉଟ୍ ସେଇଂ.
But your lordship knows, my lord, even my lord, the persons passing out in third division, they have become better teachers, my lord.
Let us see. Who knows? Who knows? Don't tell me anything about the educational system of this state.
Educational system itself is.
So we'll close it.
Yes, ma'am.
We'll close it. I will only examine. I will only examine from the angle of Article 14.
Yes, ma'am.
All right.
And lordship may appreciate that what we have filed additional counter affidavit.
Yes.
There we have tried to distinguish
Between Hema Sundar Rao and this process.
Yes, only that. That is
But I make it very clear. We are not on that. In that relates to a different advertisement.
relates to a different advertisement, and where the basis of the selection is not based upon that particular Andhra University.
But here you see the query itself makes it very clear. The query which was made by the district project coordinator.
Yes, but thereafter, my lord, the answer
we have to say, we have to treat it as it must be deemed to have been accepted. All right. Hearing concluded, judgment is up. Participants have their note of submissions and memo of citations, if any, within a week.
Item number 15.
Item 15.
Last occasion, your lordship has hear me, but the petitioner is challenging the annexure 1, my lord.
Annexure 1. Annexure 1 is the
Appellate dated 20, yes, my lord, 20. There are 3 grounds I have already, my lord, submitted to your lordship, that the land appellator didn't given me opportunity to have a say before the appellate authority, which is reflected in para 1, my lord. And so far, my lord, the another point is concerned, my lord, that so far the residential certificate which was submitted by the appeal number 6, that was, my lord, cancelled by the appellate authority under miscellaneous certificate rules. And the appointment is in the year 2007.
No, first point is enough. You have to satisfy, yes, that he was granted opportunity of hearing. If that opportunity of hearing was granted, then the other parts can be gone into.
My lord.
Otherwise, it will be plain and simple remand. If I accept it.
Yes.
my lord, lordship may pay the first part of the
First part, or heard the appellant and CDPO authority.
thereafter, my lord, the resolution of filed वकालतनामा in favor of the
heard the appellant ଲେଖା ହେଇଯାଇଛି ସେଇଟା ମୁଁ ସେଇଥିପାଇଁ ରଖିଲି ଆପଣଙ୍କୁ.
Pardon, my lord?
Heard the appellant ଲେଖା ହେଇଛି ନା, you are the
The petitioner, through our advocate, seeks some time to file her objection.
କୋଉଠୁ ପଢୁଛନ୍ତି?
Page 4, running page 4, my lord, and paragraph 2 of my
Yes.
read petition.
Yes. On the same day of appearance, take some time to file. Okay, on the same day.
My lord.
Okay. So how have you answered this?
There is no direct denial to that particular averment, only by stating that that order speaks, my lord.
Yes, Mr. Mishra, anything you have to say?
I am for the opposite partner 6, my lord.
Author sunane ho. Let him hear it again. All right. You will not be prejudiced. You will not be prejudiced because you will be also given an opportunity of hearing. The short point involved in the present writ application is that the appellate authority did not grant proper opportunity of hearing to the petitioner. Stop. Referring to the impugned order, Sri A.K. Jana, learned counsel for the petitioner, would submit that the matter was taken up, the appeal was taken up for hearing on 24/8/2022. And on that date, the petitioner, who was respondent number 5 before the appellate authority or in the appeal, appeared through a lawyer and sought time. However, the appellate authority did not grant, they rejected the prayer for grant of time and heard the appeal. Stop. Sri Jana submits that as a result, and look on this, Sri Jana submits that since it was the first date of appearance, and the time petition was rejected, the petitioner's lawyer was prevented from making appropriate submissions for want of instructions. This court finds that the specific pleading to such effect in the writ application under paragraph 2 thereof has not been answered at all by the state in the counter affidavit filed by it. In a way, this amounts to admission of the averments of the writ application. Stop. The appeal in question being heard by a quasi-judicial authority, it is necessary that proper opportunity of hearing is to be granted to all necessary parties. Stop. After going through the impugned order, this court is of the view that proper opportunity of hearing was not granted to the petitioner, for which the impugned order becomes vulnerable. In such view of the matter, the writ application succeeds and is therefore allowed. The impugned order is set aside. Matter is remitted to the ADM Jajpur to hear the AWW misappeal case number 4 of 2022 afresh, after granting proper opportunity of hearing to all necessary parties. Stop. The appeal shall be disposed of as early as possible, preferably within a period of 2 months from today, from the date of production of a copy of this order by any of the parties.
Both the parties may be also directed to cooperate with the inquiry, because they are asking time and there is a time
Further,
allocated by you.
both parties are advised, both parties are directed to render full cooperation to the for disposal of the case, for early disposal of the case. Yes.
But with the 4 weeks,
Yeah.
no, with the 4 weeks. 1 month is unless I 2 times. One time I have.
Say last time sir, 4 weeks diya itla say time hi diya is boli hame time dekha. So 2 weeks.
My brother is saying that when the first day the collector was absent, ADM was absent. But that is it. No, honestly, the present opposite partner says the certificate is genuine. Honestly, without verifying the resident certificate, he was dismissed from 16.
Item 16 and 17. Yes, Mr. Nalla, withdraw. Yes, permitted to withdraw.
Withdrawal memo is already on record.
All right.
I don't know, 19.
18 ta?
18 ta bhi infructuous hai.
Oh, infructuous. 19?
Sir, I pray let it come after one item. Senior counsel Mr. J.K. Rath is.
All right, pass over. 20?
Item 20.
First, today I have appeared. Let a transfer break now. So
today not.
Party number 5 has already filed the counter.
Your good name, sir?
What? Telegram.
Tikere Meher.
My lord.
Apang na to chi. The name of Sri Jagabandhu Sahu be deleted from the cause list.
ଆଗରୁ ସେ appear କରୁଥିଲେ
Alright.
ମୁଁ ଆଜି
I am working as Anganwadi worker. His contention is that I am not a resident of that area. Without challenging my residential certificate before the appellate authority, he filed an appeal before the ADM.
Mr. Nagar, he has appeared today.
I don't know anything regarding case.
Alright.
Therefore,
I'm accepting it, I'm adjourning it. How argument may get something? Is this matter? Hold on. On 16th August.
My lord, I pray for one counter affidavit ଦେଲେ ମୁଁ rejoinder ଟା ଦେବି opposite party number
let a copy of the counter affidavit
state counter file kori
acha let a copy of the counter affidavit filed by the state be served upon Sri Mayor who may file his rejoinder who may file his rejoinder before the ensuing date. Yes.
I have also filed an counter. I will serve also a copy to my respected senior.
Copy of the counter filed by the state as well as the private opposition party. Yes. रख दिया.
21.
नहीं इधर रख दिया. 19 टा रख दिया.
Lordship में से copy of the counter is served in the court.
मैं लिख तो दीजिए.
आगे.
19 टा रख
दिया.
19. He had asked for one passover.
Yes.
Just one passover करते ना. Because notice has to probably देखिए postal tracking report कौन है?
My lord, I have already seen this.
Sir, notice is delivered.
Yes, my lord. So that is to be treated as
notice on opposite party number 4 has been delivered as per the postal tracking report. There is, however, no appearance for which the matter is taken up for hearing. Yes, sir.
Your lordship, this is in fact the third round litigation of the petitioner.
Sir.
Earlier, the petitioner was there because he was not permitted to perform his duty. He preferred an appeal before the director. Director passed an order. That order was challenged. And ultimately, by the order of this honorable court, the matter was reheard by the director and he reviewed his order. Your lordship can have a look to the order that was passed by this honorable court. I have quoted that order in the earlier writ application filed by the petitioner. Running page 6.
Yes.
The petitioner who is working as a lecturer in mathematics of Hon'Ble High School, Higher Secondary School, +2 College in the district of Deoghar has filed this writ application challenging the order of suspension dated 21/7/2006 passed by the principal in charge cum secretary, Hon'Ble Higher Secondary School, Annexure 4, and initiation of the disciplinary proceeding initiated against him. It is submitted that though the petitioner has submitted his explanation, the disciplinary proceeding is not continuing because, according to Mr. Rathod, there is no governing body of the said college, and as per the notification dated 10th June 2004, issued by the government in Department of Higher Education in Annexure 6, all the governing bodies of all non-government aided colleges have been dissolved and the additional district magistrate have been directed to take over as president of the governing bodies at the district headquarters and the sub-collectors as the president of the governing bodies at the rest of the colleges within their respective jurisdiction. But in the case in hand, the sub-collector is acting as president of the governing body of Hon'Ble High School. According to Mr. Rathod, the disciplinary authority is the director, higher education, and the petitioner till date has not been paid the subsistence allowance from the date of his suspension. On the aforesaid premises, instead of issuing notice to the opposite parties, we direct the Director Higher Education opposite part number 2 to look into the matter and see that the disciplinary proceeding initiated against the petitioner is disposed of within a period of 6 months from the date of communication of this order. The sub-collector Deoghar and the Director Higher Education are also directed to release the arrears subsistence allowance of the petitioner within 15 days from the date of communication of this order, so also disburse the said allowance on every month in favor of the petitioner. After this was passed, my lord, an order was passed by the director, and ultimately that was the final order that was passed by the director is at Annexure 1, page 18.
Yes.
My lord, the operating person is page 19.
Hence, in view of the above facts stated above, the President GB is requested to reinstate the petitioner and allow him to perform his duty forthwith, treating the period of suspension as on duty. The salary of the said period as due and admissible may also be paid from
Further होता ना कौन लिखा है जेटा? From. No, forthwith. Forthwith.
Yeah. From with the power of the Honorable High Court complied accordingly. This was communicated. After this was communicated, my lord, the pay of the petitioner, everything has been fixed, but he was not given to join. Therefore, my lord, under the he was not permitted. Thereafter, he moved an application to the director, and at the instance of the director, petitioner was transferred and placed as a lecturer under the opposite party number 4 college, that is Laramba College, where he has been continuing. But the direction that was issued, that the arrear salary, etc., has to be paid.
That subsistence allowance.
That was not carried out. Therefore, my lord, he came once again before this honorable court in the present writ application. And your lordship can have a look to
leave without pay कर देले.
Leave without pay कर देले.
So that is what
this was passed by the director, by the sub-collector. There is no governing body. Director is functioning as the governing body in place of that. When the director has directed the pay is to be released, but he said that leave without pay. As a result of which, my lord, all my continuity, the pay, etc., has been disturbed. That is why the notice was issued. But
this is the principal which has passed this order.
Yes, my lord. The principal cum secretary has absolutely no role. Your lordship knows it is the government to take a decision. And
in one of the judgments, I don't know whether it has been challenged or not, very recently, probably, sir, you were appearing, or I don't know, I think Mr. Das was appearing. There was a submission made that in the absence of governing body, no disciplinary action can be taken. I have held that no, it will go back to the director.
Director, yes, ma'am.
I have held.
And once the director has passed order,
without jurisdiction. Apparently, Mr. Das,
yes.
I don't know whether any counter affidavit is necessary, but this is without jurisdiction.
Yeah, of the principal.
The principal
cannot pass order. Who is he? No, I'm not there. It is of the action of the principal is under challenge. That is the governing body. So the governing body is to answer.
Governing body doesn't appear.
Notice has been given.
So nothing to do with the state. State has got nothing to do here. But
rather state supports me, my lord.
Yes. Opposite party number.
That to support
opposite party number 4. Opposite party number 4 is the principal cum secretary from the Laramba College. Obviously, Laramba College से तो किसी संपर्क नहीं है करो.
Like this is the opposite party number 3 is to be. That is made sufficient, my lord. Opposite party number 3.
Opposite party number 3 which is sufficient.
Yes.
Unserved notice written gala insufficient. Neither ready gala.
Now everything is mischief played by.
No, sir. No, sir.
Report is there.
That is in respect of opposite party number 4. We are not interested in opposite party number 4. We are more interested in opposite party number 3. Notice the insufficient addressing feriasi.
Sir, they are not receiving in that event.
No, they will receive through the block education officer. We will direct.
Yes, madam.
District education officer rather.
No, the director, because district education officer will be on the schools only.
Yes, okay.
College. This is a college.
So we will ask the directorate to have the notice served. What do you say?
They are the controlling authority.
Better the collector of the.
Collector has no role to play.
No. Notice, service of notice.
To serve the notice.
Serve the notice.
Yes, sir.
The collectorate.
Yes, my
all the Tahsildar, your lordship.
Or the local, any local government officer will be cast.
Tahsildar will be better.
Tahsildar the one, BDO the one. There must be a.
For everything, they are being controlled by the regional director and director.
No, that's all right. But this is a question of service of notice.
Yes, ma'am.
We are only on that.
Yes.
In course of further hearing, it is revealed that notice on opposite party number 3, whose order is impugned in the present application, has not been served. Since it is necessary. since the earlier notice returned with the postal remark with an inverted comma insufficient address C लिखा है insufficient address, it is stated at the bar that it would be better if notice is served through any government functionary. Having regard to the submission as above, this court directs the notice on opposite party number 3 to be served by
Sub-collector Devgarh, my lord, because he is, that is a subdivision under which this.
by the office of the sub-collector Devgarh. Stop. The sub-collector shall ensure that the notice on opposite party number 3 is personally served. And the matter and the fact of such service be intimated to this court. All right. Let an extra copy of the writ application be served upon the State Council.
Yes, ma'am.
Who shall transmit the same to the sub-collector for doing the needful.
Yes.
List this matter. 23rd August. Mr. Das, please take note.
I'll personally hand over to you.
Yes. Item 20.
Item 21.
21, sorry. Yes, Mr. Satpathy.
Please, your worship.
No, batch matter.
Yes, my lord. The petitioner applied for the post of
Both of the matter ଅଛି?
other matters. Perhaps I already discussed with my friend.
Yes,
The matter of 2016 selection.
They are not related to you. Your matter.
Not related to this case.
Lord, item,
My knowledge concern.
item 2420-2017 and last item. And the last item, first item 3762 Those are separate.
They are separate.
And I have no instruction from.
So that's all right. Let us first separate these matters which are not. What about the first sub item? 721.
Raghunath Satpathy Milord.
No. Don't again. First sub item 721 of 2017. Mr. Makap is appearing. That is not related to that.
Not a related, perhaps when he is not a.
Let us see the order passed in your case. Probably भूल हो तो order ही तो देखिए. Honorable Justice A.K. Ratha has his lordship then was.
My lord.
He has passed this order, list this matter after 8 weeks along with the WPC number.
But they not related to this case.
Hearing हो देखिए. Hearing हो देखिए. यदि not तो delete कर दो आपको. Yes, go on.
In this case, it was noted mail or counter fight, but counter not solved to me mail.
Counter देना Let a copy of the counter affidavit filed by the state be served upon Sri Satpathy Land Council for the petitioner.
Just within the course.
In course of the day. Let this matter for a
Recently, Lordship decided.
What a data 23rd August. Yes, Mr. Satpathy.
Recently, Lordship decided a case just like this case, my lord.
That
is a matter related to the appointment of Swachhasevi Shiksha Sahayak, my lord, of 2006, my lord. And though the petitioner was selected and placed in the select list, my lord, she was not given engagement because of there is dispute on residency. And lord, there was a notification.
Yes, Mr.
The notification was under challenge, my lord, in the case of Chandramani Jana case, my lord, that a block unity, the resident certificate should have been.
Oh, has it been decided?
Your lordship already.
I think the senior
we
counsel
have filed our counter, my lord, distinguishing that particular.
No, in that case, I don't think it has been disposed.
Here in this case, my lord.
Was it disposed of?
Yes, your lordship disposed of this.
You have that judgment?
Yes, my lord. Lordship WPC 218887. WPC 218887 of 2013. 21887.
2013.
2013. Prafula Kumar sir.
प्रिंट आउट बाहर कर ले, प्रिंट आउट बाहर कर दे, हैं? थोड़ा पेज, हाँ बाहर कर दो, प्रिंट आउट बाहर कर दे, वो पैसा उड़े ना, मुझको बेटा चाहिए, तो पकड़ नहीं की, तो पकड़ नहीं प्रिंटर,
In our case, when our study is that here the issue is not with respect to Chandramani's case, my lord, that is with respect to
that area
of a particular person on the basis of the residency certificate. The issue in this case is that my lord, they have utilized the fake and fraud certificate, which has been cancelled.
সেটা আলগা,
And that has not
that
been,
also I have decided in some other case.
and that has not been
So
challenged.
that also I have decided in another judgment where the fake certificates were issued. And they had been given appointment. I had cancelled those appointments.
Yes, here, my lord, that is the issue, my lord. So, and
So এটা বার করিয়েন।
ନାଇଁ ସେଥିରେ ଇସ୍ୟୁ ସେଇଟା ନୁହଁ what
এটা বার
ମୁଁ
କরিয়েন।
ଏଇଟା counter ଟା ଦେଇଦେଲେ, ମୁଁ counter ଟା ଦେଇଦେଲେ,
আচ্ছা হোক, you take your counter then you will give us.
Fine.
থাক। You come up with this judgment if you are relying upon. আমি কাই দেবো?
ମତେ ବି ଟିକେ ସେ copy ଟା ଦେଇଦେଇଥିବେ।
এইটা
ଆପଣ it is available in the net.
ମତେ ନମ୍ବରଟା ଖାଲି ଦରକାର,
ନମ୍ବରଟା
ଇଏ ଦରକାର।
Place this matter on. କଣ ଲେଖା ହେଲା? Let a copy of the counter. Filed by the state be served upon.
I have already served.
Copy of the counter filed by the state is served upon Sri Satpathil and counsel for the petitioner in court, who wants some time to respond. Stop. Let this matter. 23rd August.
And in our counter, my lord, we have relied upon the decision of this honorable court. We have enclosed the copy of the order, my lord. Complete identity.
Item 22.
This is a matter where the petitioner who was appointed as a technical consultant. Counter दिया है इधर पर। हाँ दिया है। वो अच्छे होते counter देखिए। हाँ था counter। Technical assistant.
Technical assistant where?
Under the in the district of Deoghar.
Hey, under which organization?
Under the Odisha OPEPA Odisha. कौन सा था?
OPEPA था कौन?
OPEPA. And it was basically it was a contractual appointment, and he was entrusted to construct some school buildings and hostel.
Will this come under my assignment?
Pardon?
Will this come under my assignment? This is a purely service matter, not relating to any educational institution. That is why I am asking which organization you are working for.
OPEPA.
OPEPA है तो institution हो ना, educational institution हो ना. It's a organization of the government.
Yes.
I don't think this will. Yes, Mr.
2016
Up to 2016 ଏଠିକି ଆସୁଛି ତେଣୁ
2016 education in matters relating to educational institutions. This is not an educational institution.
And this is not.
This is an agency of the state government, OPEPA.
State government.
So, Mr. Mahanti, let the registry take a call in this. I'll just office to verify whether this matter belongs to the assignment of this court. ଆମ କୋର୍ଟରେ
2014 ମସିହା ପର୍ଯ୍ୟନ୍ତ ଆମର ଏମିତି 2016 ମସିହା
2016 ହେଲା ଠିକ ଆମର 2014 ଯାଏ କଣ ହେଇଥିବ
2014 ପର୍ଯ୍ୟନ୍ତ
ଅନୁଗୁଡ଼ା କେମିତି ଆସୁଛି ତାହେଲେ ଏ 2018 ଟା କେମିତି ଆସିଛି ଏ ଅଙ୍ଗନବାଡି ହେଇଥିବ ଏଇଟା ସ୍କିମ୍ ହବନି that is why I asked from the very beginning that doubt arose. That's why I asked Mr. Mahanti which is the organization you are working. Had it been any institution, technical institution?
I do understand. If it is not in the assignment, then you will not say.
ପହଲେ ହବନି ତ ପହଲେ pure service ରେ ପଡିବ देखिए let the registry find out. Item 23. 23 ଛାଡ଼ pass out. Item 24.
Minor 23.
ଡକାଉଛି ଆପଣ ଆସୁନାହାନ୍ତି 23.
So in this 20 minor, by virtue of Annex 1 minor, the person applied for appointment of ASA, and although she was selected, she could not get the appointment order, for which is approached the Honorable Court in double petition number 11922 by 13. So in that case, Honorable Court by the Annex 3 at page 20 minor directed
the subsequent advertisement है you have become an applicant लिखा है परा. There is already a further advertisement at Annex 3 and the petitioner has also become a candidate pursuant to the said advertisement. Nothing survives in this writ petition
minor
except directing the competent authority to conclude the selection process pursuant to Annex 13 within a period of 6 weeks.
in pursuant to Annex 13.
13 of that writ application.
That
Yes.
13 is Annex 1, I also annexed here.
Yes.
So instead of considering this Annex 1, first advertisement was issued by the Annex 5 series.
पुणे ये कितना advertisement करते हैं?
At page
ये किसी देखा जाओ नहीं Annex 5 जोड़ा करते हैं किसी देखा नहीं. देखिए hard file दे. So now what are you challenging? Now sir, what are you challenging?
I'm challenging that this Annex 5 is illegal. The appointment was, the selection was made as per Annex 1 or Annex 13 as per the previous writ application.
This advertisement was issued, when was it issued?
It was all 11
On
13.
Ashikon, what is the present status?
I do not know.
ताले Ashik थिबो. Advertisement is sorry ना अपन किसी stay order भी नहीं.
Cause of action might not be survived.
Might not be surviving. All right. Let this matter next week. Learned counsel for the petitioner shall apprise the court whether whether any cause of action survives in this case. Item 24.
My pleasure, Lordship. In this case, my lord, the petitioner applied for the post of Anganwadi worker.
Both are connected.
But both are connected. Both are candidates in a Anganwadi center. The Malad advertisement was published on 24/8/2015 and final list of candidates who are eligible candidates. It was published on 8/9/2015. Our prayer is that let the selection process be over and whoever eligible may be appointed, because there are objection and counter objections. State has also stated that in their counter that the process is going on. We will comply with all the objections, and who will be selected, we will give appointment.
Yes,
my lord. So that is the case, my lord. But what happened, my lord? There is a dispute, my lord, with regard to the residence, my lord. The residence certificate, my lord, produced by all the applicants, my lord, not of the 2015, the year of advertisement. That is why, my lord, CDPO kept it pending, my lord.
So that is to be considered by the selection committee. If you are aggrieved, then there is a further remedy, isn't it? So why should we keep it pending?
Yes, because of that, lord.
Taking note of the submission made at the bar, I think yes, Mr. Das.
Yes, both the petition.
Petition can be.
Both the writ application.
Lordship, for a moment, my lord, the counter affidavit, lordship can have advance, my lord.
अब देखिए दरकार हो.
हाँ, से लिखी जाने से यार. से लिखी जाने what friend submitting for lordship, my lord. The counter affidavit is C/5, my lord. Lordship can have a glance, my lord.
Paragraph 5.
My lord, C/5, my lord.
Yes, paragraph 5.
Paragraph 1, my lord. The counter affidavit filed in 7103 of 2020.
हाँ, सही तरह paragraph 5 के सब कुछ.
Paragraph 5, I'm showing, my lord, annexure, my lord.
Annexure कितने?
C/5, my lord. Here, my lord, the selection committee meeting was held on.
So this is now at this stage it has been kept.
Kept, my lord.
Yes, sir. Document. Unnecessarily, this has been locked up since the year 2020 or 2015 rather.
And in the advertisement, my lord,
All right, both the writ application. No, I will not pass any order on merit. I will not issue any order. It may prejudice either of you. Why should I?
Whoever will be selected will be given.
Both the writ applications are data को message करो. In the course of hearing, it has come to light that selection committee meeting for selection of Anganwadi worker for it called Khanta Samalai to Anganwadi Center was held on 4/8/2016 under the chairmanship of the sub-collector Patnagar. Objections were filed against the residential status of the candidates. Stop. The matter has remained pending since then. Because of pendency of these writ applications.
And also report of the Tahsildar Patnagar was also awaiting.
As also for want of submission of report by the concerned Tahsildar. Stop. Since the selection process has been stalled, this court is not inclined to keep the writ applications pending any further. Stop. Both the writ applications are therefore disposed of, directing the sub-collector Patnagar to take steps for conclusion of the selection process as early as possible, preferably within a period of 4 weeks from today. It goes without saying that it shall be. If you are agreed, you will challenge. Why should I say that?
Every candidate has filed their respective documents and objections, everything.
That's it.
Here the CDPO is the authority, my lord.
The sub-collector, I have given it because under his chairmanship, the selection committee. That is why I have directed it to the sub-collector so that he can pass necessary. CDPO file sub-collector.
Yes, obliged.
So he is the authority.
EO, but he has not replied nor had informed me anything. Should I call it next week? I will try to.
Item 26.
Sir.
26 some other. Yeah, next.
Regent of next.
9th August. Item 27. 6 to 9th August.
So on the file for I, my lord, during pendence of the writ application, the fresh notification was advertised for the filling of the post, my lord. Yes. Yes.
27.
এটা কি 15/7 1 তারিখ হচ্ছে লাস্ট ডেট।
In fact, the counter affidavit in paragraph 15, they have said as to what has happened. Yes.
If otherwise the matter is ready, you can take it out. The only thing is that the driver of the party is not present.
Yes.
Yeah.
No, we hope so.
Committed that the requirements of this application. The place advertisement. For selection of Anganwadi worker. In India, two Anganwadi center has been issued. Copies are advertised. Fees of not very good. And they impose the answer by. There is the application is Anganwadi ready to have it forward. Proceed further, proceed in the interest application. They need to unnecessary complications. In such way the matter, this could direct the question of then the advertisement that the fix services of the shall be made still till the next year.
If any finality has reached, it will.
It will show
Oh, yeah.
This matter of
The 23rd August. Item 28.
Wait, please, Lord. Well, the petition is challenging annexure number 7, wherein appointment was given to an ASA worker. My lord, on the last occasion had issued notice and for the appearance of OP number 5, who was the selected candidate. My lord, I'm challenging on the ground that earlier I was selected. Earlier I was selected because of the fact that the OP number 5, who was also an earlier, had also filed application earlier, and she was disqualified because she has not attained the age of 25. And another candidate withdrew her application. Therefore, I was to be selected. But instead of carrying on with the selection process, what they did is that they kept it pending till 2022. After a period of 2 years, they convened the meeting and they cancelled the entire selection process and they issued a fresh notice for appointment. I'm agree by that.
Yes, we have received the para-wise comments, but it is not very clear. It is not very clear. I will seek for further clarification and file.
He's allowed to put as an offer. Yes, offer further instructions. This is matter.
23rd August.
23rd August, will be final. Then
Well, interim order to continue. Grateful.
Return to do file manner 3 weeks time will granted. Interim order.
Item 30.
The government has filed counter and rejoinder to that counter is necessary. But one prayer of people lordship is that another writ application similar to the fact may be tagged with this as a result of it can be heard analogously and can be disposed of. No, that is 30 your lordship. I'll file rejoinder in the meantime. But WBC number 11,802/2016. It is similar matter challenging selection list. But in the meantime, appointment was given to the contesting rival party. So if both the writ applications be hard analogously, it will be better, it will be disposed of.
Similar matter to the conducted.
11,802 of these.
30th August.
30th August, WBC number.
11,802 of 2016.
What is this matter about?
Your lordship, Jogan Soyak.
In that case,
State
selection was challenged. Selection was challenged. The interim order is that any appointment made to this post is subject to result of the writ petition. So there was no stay. So naturally, because I was working with the Gram Panchayat.
You are the private opposition.
Yes. I am the beneficiary. So since I was working as salesman, I got priority over the matter as per the government circular. and I am appointed. So now the appointment he has challenged. Their selection he has challenged. In this case, he has appointment he has challenged. That is what I said.
It will come up 38th August. What did you find, Mr.
Hard copy of the counter in this case.
The DK files hard copy of the counter. Already e-filed, e-filed. So then we can come back.
Item 31.
31.
Last time I lost the directive to take instruction. But
we needed to read that application for. No, that's interesting for all.
notice has been, request has been filed in time manner.
Paragraph 3 as said that SL Putna claimed the additional government accepts notice of their own position. In spite of that, I said that
Double ହେଇଯାଇଛି sir. ସେଥିପାଇଁ ଆମେ କେବେ notice ଟା ପଠେଇଦେଲୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କପି ଦେଇନୁ।
Counter patient.
Counter ପାଇନି।
It's a government has already filed a counter. He filed on 24/7.
Copy ଦେଇନାହାନ୍ତି।
Hard copy. Yes, on 24/7.
copy there on the who wants some time to go with this matter.
6 September.
6 September.
Interim order में कैन पास।
Item 32.
May I please, Lordship, my lord, mediation, my lord, the wife wants to go, but the husband doesn't want to take, my lord, till that. And my lord, there is 13-year-old daughter with the wife, resides at his father's house at Balangir. Therefore, may kindly be transferred to Balangir, my lord. And partial mode, everything the husband can do.
Lordship, I am for the husband. Lordship, on the last occasion, it was a directed for conciliation, if possible, between the parties. So, due to some difficulties, husband did not reach. This is Your Lordship.
Item 33.
My lord, in this case, my lord, present petitioner, in last occasion, your honorable court directed to file the mutual divorce before the Lord Judge Bhubaneswar, my lord, and there is a settlement, discussion of settlement, 5 lakhs for the return money and 50% of the house, which is in Calcutta, and thereafter permanent alimony in 10 lakhs. Well, decided and
matter has been settled. No, two cases were pending in two different courts. So I also suggest that the case pending at Raulkela Family Court be transferred to the Bhubaneswar, because wife has filed the case at Bhubaneswar, husband at Raulkela. So both the cases will be merged, and accordingly they will file their joint petition. But one thing, your lordship may record our concession, because they may again grumble for the sake of money. That will be better. Your lordship may not pass any order, say that the parties agree. Yes. तारे हेची जहाँ हेची मु कोई दूची राहुल कोटे कालकाटा कोटे घर अच्छी दी जन को नारे ताकू सेमान डिसाइड कले ताकू सेल प्रोसीड 50-50 हो बिक्री कर 50-50 है जो व्हाटएवर द मार्केट वैल्यू में भी
ବାକି ହଜବେଣ୍ଡ ଦବ 5,5,10,10 ଲକ୍ଷ ଟଙ୍କା ଦବ ସରିଗଲା ଏତିକି ତ।
5 lakhs ହଉଛି ପୁରୁଣା ପଇସା।
ହଁ 5 କହିଲି 10 ଲକ୍ଷ କହିଲି।
5 lakhs ପୁରୁଣା
ହୁଁ
ମାନେ
ପୁରୁଣା
ମାନେ ଯୋଉଟା ଆମ ପଇସା ନେଇଥିଲେ।
ଆମ ପଇସା ନେଇଥିଲ
ମାନେ that money taken from our account.
10 ଲକ୍ଷ ଯଦି ନେବେ କରିବେ କରନ୍ତୁ ନ କରିବେ ନ କରନ୍ତୁ। My lord, I am just bringing my lord's kind attention how the things were being played. While the both divorce petitions were pending, the wife approached the State Women Commission. There is a agreement, and in that agreement between the husband and wife, husband is to pay 5 lakhs and the sale proceeds will be divided. Now my friend approached me, I have somehow convinced, let's pay another 5,000, 5 lakhs, the matter will be. Now my friend says another amount, if this will go on.
That is not but permanent alimony is 10 lakhs.
କୋଉଠି 10 lakhs ଅଛି ଆଜ୍ଞା? women commission ପାଖରେ ମୁଁ ଦେଇଛି। Your lordship may go to the
my money, their transfer for their money 15 lakh
ତାହେଲେ ହବ ନାହିଁ, ଆପଣ ଟ୍ରାନ୍ସଫର କରିଦିଅନ୍ତୁ, ସେ କଣ୍ଟେଷ୍ଟ କରନ୍ତୁ। Your lordship have a grant to the women commission decision which has agreed.
If there is some disagreement, I cannot record.
Your lordship recorded. Yes. 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 Because
In course of the land for parties, submit that the land has been adequately resolved between the parties. To the effect of the failed to fix of the
Joint house. Joint recorded house.
can be distributed equally between them.
as per the present value.
Sale proceed to ଯାହା ହବ।
ଯଦି କିଏ ନେଇ ତାଙ୍କ ଭିତରେ ନେବା ପାଇଁ ଚାହିଁବେ ନେଇପାରିବେ କିଛି ଅସୁବିଧା
ସେ
ଆଜ୍ଞା।
Some of the sell that is to be paid by the husband.
Now, 5 lakhs for the permanent alimony and 5 lakhs for the return.
10 lakh ତ ସରିଲା।
ସେଟା ଯେ ଆଗରୁ ଯେହେତୁ ମହିଳା କମିଶନ ହେଇଥିଲା, that is exist.
Towards permanent.
So that everything will be clear.
ମାନେ ଆଉ ପୁଣି 5 ଲକ୍ଷ ପୁଣି କହିବ ମହିଳା କମିଶନ ହେଇଥିଲା, ଏଇ ସବୁ ଯାକ ଆପଣ ସାରିବାକୁ ଚାହୁଁଛନ୍ତି? ଆଉ
This court directs that the proceedings in CP number 310 sending in the court of record that can be put down can be transferred.
Bhubaneswar.
Judge family court.
Bhubaneswar matter. Two. By the CP number matter. नहीं ସେଇଠି କେରେ ଭୁବନେଶ୍ୱର ସିପି ନମ୍ବରଟା ଟିକେ ଲିଖିଦେଲେ ଗୋଟେ ସେଇଟାକୁ ଆସିଯିବ ଆଉ ସିପି ନମ୍ବର 152 ରେ ଏଣ୍ଟାଙ୍ଗଲ ହେଇଯିବ ସେ ଦିଟା ଯାକ ଠିକ ଅଛି
ସେ କେସଟା ଆସିଗଲା, ସେଠି କହିଦେବ ଦିଟା କେସ ଶୁଣ।
item 34 obligement.
May I please, your lordship, on behalf of Mr. P.R. Singh, I be permitted to submit, your lordship. My lord, this is a transfer petition. The 138 proceedings which has been filed by the my lord, my petition is paying for the transfer of the 1cc case which is pending in Malkanagiri, your lordship. My lord. My lord. My lord, it is been filed only to harass the petitioner, your lordship. If your lordship will see in the complaint petition itself also the cost title in the address of the complainant is been mentioned in at Kotak, and the person accused person respondents is at Dhankanal, your lordship. On the last day, your lordship has already heard the matter. In the lordship 407 is very wide also. There's a confidence of parties there to be taken into consideration. In this case, your lordship will see the complainant
himself is from this side, the Cuttack, and the accused also from the Dhankala, your lordship, the other witnesses also from this jurisdiction, they said.
Yes.
So that is the reason, your lordship, and while the argument also, my learned friend was arguing the substantive clause of that 142. In I have given some judgment also in Appeals Court also. It is stated that in the, because your lordship's prior power is in 407 is quite wider than the 406, your lordship. It has been inserted, if 142 has been inserted subsequent in the amendment. It is, I'm just referring to the right to that judgment, your lordship. I have already given in my written notes of submission. That is, your lordship, in the 2023 judgment, your lordship. We kindly see at paragraph 13, your lordship. It has been discussed prior 142. If your lordship will got it, then I'll just read that judgment. Therefore, the institution of the first two complaint cases before the courts at Nagpur is keeping with the legal position obtaining law. However, the contention that the substantive clause in section 142(1) of the Act in 1881 would override the 1406. This is in the Supreme Court is a 406, your lordship, that it would not be permissible for this court to the transfer and said complaint case in the exercise of power thereunder cannot be there countenanced. It may be noted that no substance clause was there in the original section 142 itself, because the 142 is the cognizance. If your lordship will see that cognizance of offences in that itself, and was not introduced by way of amendment in the year 2015 along with section 142(2). The said clause merely has in reference to the manner in which the cognizance is to be taken in offences under section 138 of the section. As a departure has to be made from the usual procedure in as much as prosecution for the said offences stands postponed despite commission of the offence being complete upon condition of the check, and it must be necessary be in terms of the procedure prescribed. The clause therefore has to be read and understood in the context and for the purpose itself, and it does not lend itself the interpretation that the section 406 would stand excluded vis-a-vis the offences under section 80. The power of this court to transfer pending criminal proceedings under section 406 does not stand abrogated thereby in respect of offence under section 106. It may be noted that this court exercise of power under 406 in exercise of offence on section so the time of 402 held in a so and so the judgment. This court took note that the fact that the offence they are under section 36 has arisen of one single transaction and found it appropriate in interest of justice, there's also has to be transferred together. We therefore hold that not to have anything, not substantive clause in 142(1) of the thinking, the power of this court to transfer the case in the 406, because it's in the 406 the transfer is a I'm in the between the because I am I have approached your lordship under 407. In the 407, if your lordship will see, the power of conveyance of party is also there in the act itself, in the section itself. So complaint is the cause of action, the transaction, the party between they have already previously they have also transacted from Bhubaneswar and this only in this case only he has. There are documents I filed also that there are previously some transaction also interest between the parties with the checks were deposited in Bhubaneswar and Kotak and they're transacting on that way. Only to harass the petition, it has been deliberately the complaint has been instituted in Malkanagiri.
Yes, Mr. Jana.
Lordship may kindly see the transfer petition para 1.
Para 1.
Madam.
Yes.
Last 5 lines. Madam.
Yes.
On the ground that the complainant and the accused person are belonging to the Dhankana and Athagar district. And this is the first point. And second point is that another case arising out of the same dispute is subjudiced before the learned SDM in this. Then your lordship may kindly come to paragraph 4. PS4. Middle person, madam. The address of the complainant mentioned in the complaint petition as well as the legal notice issued by the council shown as District Kotak, madam.
Then, my lord, there are three grounds they have taken. So far, the first ground is concerned. Now, I am putting a question to myself that this is a proceeding under section 138. A check was bounced. I presented with a particular branch. And law says, my lords, under section 144, clause, subclause 2, and 144, 2, subclause capital D. Whether I have rightly filed a complaint petition before the competent authority or not. To that effect, my lord, law has permitted me to file an application before the competent authority, and the learner SDJ Malkan is the competent. So far, my lord, the address is concerned, my lords, there is no such provision in the NI Act that a case has to be filed at the residential area of any of the parties. Number 3, they stated that the convenience of the party. This in the several decisions of the apex court and the different high court, it is crystal clear that that if any of the parties is saying or raising a question of conveniency, it has to be taken into consideration by the learned trial court. To that effect, I am answering that the opposite party has not raised that objection before the original court, that is SDJ Malkan. In a straight cut manner, he is raising this question before this honorable court. So far the resident is concerned, my lord, I am also relying some judgment. I have already filed, my lord. Another judgment I am also giving. You filed a note? No, pratham dei deithili sabu. So far the kahi dei nahi. Pratham dei nahi.
Written objection upon file.
हाँ से written objection सब दे दी
objection
हाँ सब
then what
आउ गोटे judgment मु दउची so the resident it is not a bar that I have filed a petition no having no competence, and so far the convenience is concerned, the learned apex court stated that it can be, my lord, dispensed with, and in necessary circumstances only, if any party is, my lord, having no convenience, he can appear in a particular circumstance or particular date. It is not necessary because it's a summary trial process. It is not necessary at all. And so far, my lord, the witnesses are concerned, this is purely, my lord, documentary evidence, based on the documentary evidence. What they said, my lord, that 2 witnesses are belonging to here. Convenience they had not raised at all before the learned trial.
Correct. That's all.
And so far the 407 is concerned, my lord, of the CRPC, he has to be satisfied that it has to be overcome. 144(2), 144(2), capital A.
Okay.
And I, my lord, I belong to the Cuttack district. He belongs to the Dhanagar district.
All right, I get your point. That's all. That's all.
My lord, I know some judgment.
The concluded judgment is out.
Only one point, your lordship. That other before the same transaction, there's a case filed against him. It is been decided by the SDGM.
Two matters here.
Dita matter. Not the court.
No. But there it's all right. Yes. Item 35.
Your Lordship, I am appearing from the side of opposite party on behalf of my learned senior Krishna sir. Due to personal inconvenience, he is not available. Your Lordship may kindly add.
Yes. Yes, Mr. Jana.
ଗୋଟେ ଜିନିଷ କହିବାକୁ ଚାହୁଁଛି ଯଦି ଆମ ଏଗେନଷ୍ଟ ଗଲା କନଭିନିୟନ୍ସ ଟା ଆମ ଢେଙ୍କାନାଳ ବି ହେଇପାରିବ ଦେଖ ଯଦି ଗଲା ଲର୍ଡସିପ ଡିସାଇଡ୍
Your Lordship may meanwhile may contact.
Yes, what do you say? He's asking for time.
Yes, my lord.
When do you want?
1 week, Your Lordship.
You are asking time on behalf of Mr. Pusti?
Yes, sir.
All right.
Your Lordship,
prayer for adjournment is made on behalf of.
Consent.
Yeah, all right.
One.
The RN proceed. Then comes for the opposite party. Let this matter
9th August.
on 9th August.
Your Lordship.
My lord, interim order.
Interim order.
Interim order to continue. In both the cases.
Item 36.
Now, and for the opposite party, your lordship may see the last order. Last order, they also did not appear. Your lordship passed over, put up of accommodated after lunch also. Today also they are not appearing.
Today also I'll pass it over till after lunch and thereafter. Well, I'll make that observation and well, let us give an opportunity. Always it is better.
No.
Dismiss kar dal to silent kote mein lagyo.
As an officer of the court, I should point out the last order.
Yes. No, you have done your duty. Yes.
Item 37.
My lord, on behalf of Mr. Prashant Kumar Sahu, I'm seeking adjournment. His
This criminal appeal, why? Bail. Bail.
uncle died. Sorry, pardon?
Why has this criminal appeal come to me? This is not in my assignment. Janna Bail.
Bail, yes. Interim bail was granted.
All right. Let's this matter 1 week after as paid for.
Item 38.
My lord, it may come 12 August.
As per our convenience.
My lord, actually his uncle died.
16th August. Yes.
Oh, please.
Item 38.
So yesterday's matter. Well, yes. You had completed. Mr. Panda.
Sorry. I'm very sorry. I was not.
Se ପଛରେ ବସନ୍ତୁ ପଛରେ ବସିକି ଦେଖନ୍ତୁ କଣ ଲେଖା ହେଇଛି ସାମ୍ନାରେ ଚେୟାର ପଛରେ କଣ ଲେଖା ହେଇଛି ଟିକେ ଲେଖା ହେଇନି
ଏଇଟା ଲେଖା ହେଇଛି ସେଟା ବି ନାହିଁ ସେଟା ବି ଲେଖା
I'm sorry. I was.
No. Come on, Mr. Panda. Yes. I think you are completed.
Yes.
That map and
yes.
The house was ABCD.
Mine.
All right. Yes. Short point is that 26-9 report.
Yes. That report. Here, what happened?
Exhibit X.
When the suit was filed, it was a land. No house was there. But when the commissioner went to measure it, there was a house. It was constructed thereafter. Therefore, he has described it as a suit house. Number one. Number two, what yesterday I pointed out, the plot numbers are clearly there in the report. Basing on the facts and circumstances, I measured the suit house, which was identified.
So, where are you reading from?
But that commissioner's report, page 3.
Page 3, yes.
Yes. Well,
basing on the facts and circumstances, I measured the suit house, which was
identified by the parties. It is seen that in my map, ABCD, the suit house, that is AB so and so, covered under area 61 decimals in plot number this. So, the plot numbers are mentioned clearly. And moreover, if your lordship, the second point is also the same thing.
Same thing. Third is also same thing.
Third is also the same.
Where is the dimension of the plot? Where are the
dimensions? If your lordship look at the sketch which the commissioner...
So that is left to the court to now draw an inference. How? That is not permissible. He has to give the dimensions of the plot itself. This is the plot. ABCD is the suit house. The other part is the plot. So total area is this. We are concerned with the area.
Because I am submitting because if your lordship will look at the map, the area, the map which is the line outline which the commissioner has given, it is on the road. It is not in the inside the plot. It is on the road. This portion is the road as mentioned below. And this line is on the road. So,
the question to be decided by this court which ought to have been also decided by the first appellate court, is whether the writ that was issued to the survey knowing commissioner, was it fulfilled? In a sense, what was the writ for? Writ was never intended for to measure the dimensions of the suit house, but the entire plots. From the report that we find prima facie, and I'm not, this is not my final opinion, but the prima facie we find that he has only measured ABCD. ABCD is the suit house. He doesn't say anything about the dimensions of 2362 and 2363. Because here there is a case where there is a case of excess area. That is an allegation. We don't accept it, but there is an allegation.
Excess area, but if
So I think in the interest of justice, he should again measure.
No, I think my submission is second submission. The plot numbers which are mentioned here is the plot numbers which are in my sale deeds exhibits. Their sale deeds never show any plot number or khata number.
Correct.
So therefore, that cannot be their plot.
So let us go to the LCR. So let us see what was the order for which the 26-9 application was filed. What was the reason for filing that 26-9?
Measuring the suit.
नहीं, त्याचा कुठे रिट इश्यू होती ना?
Yes.
What a specific commissioner's report gala. Let us see the. It first appellate court है इतना तो?
First.
अच्छी.
नहीं सेटा
No, this
remand order from this
court
in RSA.
अच्छा RSA रे.
RSA 91.
Where is that order? You were referring to that order yesterday, probably.
Yes. Who is referring to that?
Let us go through that order. Then step by step we can find out. I want to see the writ.
Yes. Read.
So read no, but that order corresponding order sheet is na. Where is that RSA order, Mr. Mantri?
RSA
record also RSA 90.
It is in record.
That include ही कैसी?
Tadre chilla.
No, it's not there.
I can supply a copy.
Yes, please.
No.
Time set a remand ala. We must see.
Because of the identity problem.
In the instant case, the question of law is raised as to the necessity of appointment of the survey knowing commissioner or order 26 rule 9 of the CP. Following the aforesaid decision of the honorable, since the identical facts and circumstances are available, the judgment review matter be provided.
The last page.
To deputy the survey knowing commissioner obtain his report and allow both parties to argue on that report.
Why this question arose? I am just placing it because before the lower appellate court, an application for appointment of survey knowing commissioner was filed.
It was rejected.
That was rejected. That rejection was under consideration in the last. Therefore, this honorable court came to a conclusion. No. Rejecting the application for order appointment of commissioner was wrong. That is why from here it was remanded.
Deputy survey knowing commissioner to obtain his report and allow both the parties to argue on the survey knowing commissioner report.
So let us see the RFA order.
My lord.
RFA re कौन order है? Basing on this.
RSA 91.
RFA. Lower court कौन order है? Straight away the
previous order.
Para 8 lordship can straight away just reflected.
Para
8 of the appellate court judgment, lower appellate court judgment.
Lower appellate.
He has just reflected the area given by the commissioner.
That you had shown yesterday probably.
Yes.
This court would like to know whether the commissioner's order fulfills the requirement.
No, that has not been only measurements given. This is the measurement given by the commissioner. Therefore, the commissioner report is accepted and
he stated by parties during argument that the first one link as per exhibit X, the suit property is covering plot number so and so and so and so. In plot number so and so and the area CDD1 C1 is covering plot number so and so. That is the observation of the lower appellate court. And previously that plot number so and so, plot number so and so is to be understood as plot number so and so and so and so. This is the observation. But here it is mentioned the parties, it is stated by the parties during argument that 1 feet, 0.1 feet links as per the survey. So it is stated by the parties, number one. Number two is this honorable court, when while remanding the matter, this honorable court clearly stated, clearly observed that it will be the surveying commission will give a report. The parties will argue on the report. There they did not object to that. So therefore, at this stage, there is no scope for them to object to it. They have accepted that report. And as per that report, the honorable court has, the lower appellate court has observed that that is the plot, suit plot.
This you have to answer, Mr. Mahathir. This you have to answer because you have not filed any objection to the survey knowing commissioner's report.
There is no scope.
Why?
Because of the remand judgment passed by
the remand judgment, the court says, this court says very clearly that allow both parties to argue on the report of the survey knowing commissioner. Arguments you could have submitted an objection saying that no, this does not fulfill the writ. It does not fulfill the mandate of this court. You could have argued that.
We have argued on the report, but no evidence was accepted. Even the lower appellate court comes to a conclusion.
We'll see. We'll see. Then what else?
That is one. Number two is regarding the plot. The plots which they said will be their plot, which was the ROR was published in their name and so and so. Where is the plot? They don't have in their sale deeds. No plot has been given. They have purchased it in 1985. According to them, in 1980 the settlement was over. So plot numbers could have been mentioned, as it has been mentioned in my sale deeds. So where is their plot numbers? There is no plot numbers. Where from this have purchased? Only the measurement. Number one. Number two, my plot from the inception of the suit, my plot size is given. It is 60 by 45. Their plot size, they say it is 75 by 45. This plot is 60 by 45.
No, but the commissioner does not say anything with regard to the size of the plot. He only confines his report to the house present on the suit land, which is A, B, C, D.
He has said the house in plot number so and so.
Plot number so and so. But when
so that plot is mine.
He could not have relied upon your schedule.
Yes,
he could not have relied upon your schedule. He is an independent person.
So what he saw, he has given. He saw that it is that plot.
I have a doubt because you see, the whole purpose is to pass an enforceable decree.
Yes.
Isn't it?
Yes.
Now their claim is that land in excess of what was available to the plaintiff has been sold.
My submission there would be all the other things which my learned friend has argued has been dealt with in the RSA number 91, which has attained finality. They have never challenged those findings. So those findings are settled. Regarding the sale to the 5 persons, that has been settled. If your lordship allows me, I'll place from para 14.
Then I've seen it, but I will continue next week.
Next week.
Yes. Let us supplementary list. Sorry, any argument? I'll 10 minutes. Sorry. I'm deliberately keeping it to next week because a lot of judgments are pending. That's why. 1st August. Heard further arguments. List this matter. Heard further arguments and part. List this matter on 1st August. Yes. In the supplementary list.
1st August is Thursday.
Thursday.
Item 39.
Pass over. 40.
Item 40.
Pass over.
Item 41.
41. Yes.
Madams, the opposite party number 2 is present virtually, madams. There was a direction for the personal appearance of both the parties.
I'll pass that order.
I may be excused, my lords.
No, let her argue. Please take. Please argue.
Madams, as per-
Rule.
It was to be considered.
Filed an additional affidavit stating that during pregnancy, the opposition number one husband and opposite party number two wife had an amicable settlement of the dispute. Accordingly, joint petition is filed in the court of STJ Hon'Ble for legal prosecution. The SDG was directed to consider the joint application. So what order was passed?
My lord, the learned court below has rejected it, my lords.
Whatever. Whatever. Are these not compoundable offences?
No, my lord,
No, my lord.
that is what.
498A.
Which the
498A and 406.
Right.
Yes.
You should have filed 482.
My lords, we have filed this present application where both the parties are now appearing.
This is a 482 application.
Yes, yes.
Why has it come to me?
My lords, because one of the 482 was disposed of, was withdrawn before your lordship.
So we'll hear
Back
this.
to you.
We'll hear this. I mean, this order has to be challenged.
No, my lords, that order which we have annexed is there before your lordship, my lords. Now that the order has come straight from the magistrate.
Yes.
My lords, if your lordship can exercise 482 here itself, because we have challenged the petition for discharge in the main prayer. Now that there has been an amicable settlement and both the parties are appearing, they are also appearing from their lawyers at Hon'Ble, my lords.
No, I think the lady is present with a lawyer, but this gentleman doesn't seem to be presented by a lawyer. Who will identify him?
My lords, I am there. We are there for the petitioner and we have his identity proofs also. He's not.
His identity proof?
My lords, his Aadhaar card. Original Aadhaar card.
All right. As directed, the parties are present virtually. Petitioner number one.
He's the husband, my lords.
Sheikh Sadab Kadir. And what about the other petitioners?
They are
the family members.
Petitioner number one.
Who is the husband of opposite party number two? He is present virtually, being identified by Sri Sudipta Ponda, learned his counsel. Further, his
Original
Aadhaar card is produced in the court, which is to be returned on production of
I have
attested
photocopies
Xerox
of all.
copies. Stop. The opposite party number two, Saher Sania, is present virtually, being identified by his lawyer. Mr. Das, you are appearing?
Sir.
Mr. Akshay Kumar Das. And where are the documents? Identification documents?
That is Aadhaar card.
The moderator can scan and send to your
Yes,
lordship.
Where is our staff? Our staff?
Yes, my lord, Pranam.
The staff of the court attached to the virtual court has received the original Aadhaar card,
Yes,
which he shall scan and transmit to this court.
Yes,
Yes. We'll take it up. We will consider it next week and let the personal appearance be dispensed with.
My lord, as your lordship.
All right. So list this matter next week, because we will have to see the order of the SDGM is also there. List this matter next week. List this matter on 1st August.
My lord.
1st August. The parties need not appear anymore.
I'm grateful.
That's all. I'll consider the main application of 482. All right. Yes. So what to do here in this case?
Well, since the order of discharge was under challenge, my lords.
Where's the joint application?
Joint application, my lords, that was filed by Annexure 7, my lords. Annexure A in IA number 1736 of 2024.
Yes. I forgot to ask him about whether they have.
They're still there, my lords.
Yes. Let me ask. Yes, Mr. Kadir. ଆପଣ ଏଇ ଯୋଉ ଆଫିଡେଭିଟ ଜଏଣ୍ଟ ଆଫିଡେଭିଟ ଆପଣ ଫାଇଲ କରିଛନ୍ତି?
Yes, sir.
ଆପଣ ଏଇଠି ଦସ୍ତଖତ ଦେଇଛନ୍ତି 26/6/2024 ରେ
ଆଜ୍ଞା sir.
କୌଣସି ପ୍ରେସରରେ ସାଇନ୍ କରିନାହାନ୍ତି ତ?
No, sir, no, sir.
ୟେସ୍ ଆଣ୍ଡ ଦେନ୍ ସାହେର ସାନିଆ ଆପଣ ସାଇନ୍ କରିଛନ୍ତି ଏଇ ଜଏଣ୍ଟ ଆଫିଡେଭିଟ୍ ଆପଣ ଦେଇଛନ୍ତି
ଆଜ୍ଞା ସାର୍।
ଆପଣ ନିଜେ ସାଇନ୍ କରିଛନ୍ତି କୌଣସି ପ୍ରେସର ଆପଣଙ୍କ ଉପରେ ପଡିନାହିଁ
No, sir. ମୁଁ ନିଜେ ସାଇନ୍ କରିଛି।
ଆଚ୍ଛା ଆପଣ ଏଥିରେ ଲେଖିଛନ୍ତି ଯେ କେସ୍ ଆଉ ଆପଣ ଆଗେଇବାକୁ ଆଗେ ମାନେ ଆଉ ଆଗେଇବାକୁ ଚାହୁଁନାହାନ୍ତି
Yes,
30
sir.
ଲକ୍ଷ ଟଙ୍କା ଆପଣ କ୍ୟାଶ ପାଇସାରିଛନ୍ତି ପରମାନେଣ୍ଟ ଆଲିମୋନି ହିସାବରେ
Yes, sir.
ଠିକ ତ
ଆଜ୍ଞା sir.
ହେଲେ ଆମର ସେଇ ଅର୍ଡରଟା କରିଦେବା ଆମର ଯୋଉ
Because mutually the divorce has also been done with Khulla being affected.
No, I can pass. I would have passed that order right now. The
Okay.
problem is the SDGM has passed some order.
Well, he has simply passed this order stating that since they are not compoundable, the joint petition is not maintainable in view of that fact. That order is there.
Yeah, that is there. You don't have to file
Yeah,
it.
the
It's there.
certified copy.
He has
of it.
already communicated it.
Yes,
So over and above that, we can pass this order.
yes, well, I think your lordship can exercise.
No,
full-
482 can be. No, I mean, our 482 is a compromise. We say, go to Kosovo. All it. All it.
Disposed of.
Disposed of.
Dispose. I'm grateful. my lord.
बाकी जा रहा है
I'm filing all the Xerox copies of the identity proof of all the petitioners being attested.
Yes. ଆଉ ବାକି ସେ ତାକଠୁ ସେ କୋଅର୍ଡିନେଟର ଯିଏ ଅଛି ତୁ ପଠେଇବ remote point coordinator or something whatever is his
Item
All right.
53, I need permit to withdraw.
item
53.
53 53 permitted to withdraw
What's your? 15 is common matter. That's the same thing. The arbiter, the main accused.
after that चलो pass out last outside ଦେଖିଦେବା ଆଉ 43
By, modification of order dated my lord 31/10/2023.
yes
Under that, my lord, release on bail, in event of surrender, he shall be released on bail. And directed also, the petitioner shall deposit a sum of rupees 2,000 every month, my lord, for the welfare of a minor child. I pray, my lord, 1,000, my lord, farmer regularly he is depositing, my lord. अथवा 10 ମାସ ହେଲା ସେ ଡିପୋଜିଟ୍ କରୁଛୁ from date of order, release on bail, my lord. Regularly he is deposit, my lord. Difficult ହଉଛି ଚାଷୀ ଲୋକଟା ଗରିବ ଲୋକଟା ଟିକେ
oh that child
ଆଜ୍ଞା
ଛୁଆଙ୍କ କେସରେ ହବ
1000
no Mr. Barik
କ୍ଲିୟର ହବ ତାର
no who is there to pray for the child the child will have to bear the tag of illegitimacy for the rest of its life considering that still I granted you bail
1000
No. In this application, there is made to modify the order dated 31/10/2023 to the extent of reducing the amount to be paid by the petitioner in favor of the minor child every month. Stop. It is submitted that the petitioner is a poor man, poor farmer, and hence it is proving to be difficult on his part to pay the amount. Stop. After considering the submissions, this court is not inclined to modify the order as any amount paid, as the amount is has been directed to be paid in the interest of the minor child who was born out of the sexual union of the petitioner with the victim. The application stands rejected. Yes.
Item 44.
May I please, Your Honor. My lord, notification of order dated, my lord, 11/10/2023, my lord. And in this case, my lord, one accused person is already released on bail, my lord.
So,
Session G.
parity.
Clarity, my lord, अच्छी से जीवित देते नहीं.
Yes, yes.
Clarity अच्छी, my lord.
अच्छा कौन करे parity तो अच्छी parity जीवे को parity पर अच्छी
My
so যদি কোর্ট কে যাইছি বেলে সেটা কোর্ট কনসিডার করবেনি why are you apprehensive? So you show that order, you will be granted bail. I have clearly mentioned that shall be considered on its own merit, maintaining parity. All right. Chalo. Yes.
ସେମାନେ juvenile ରେ ସେ ଯାଇଛି.
Yes, yes.
Juvenile ରେ ଯାଇଛନ୍ତି.
Huh, so? I said meant to maintain parity.
My lord.
You will maintain parity. Yes.
45.
किसी ने
Published me.
I am saying not pressed. Not pressed. Item 45. Yes, item 45.
We have appeared in this case, your lordship, in disposed of matter, our name has not been reflected.
You are appearing for whom?
Petitioner.
I am for the informant, your lordship. They filed one modification application.
What modification?
On the same, both the matters were listed. Your lordship may look at the order passed in the
May I
page,
pray, your lordship, copy?
वो देखते खाली मैटर तो कौन जानी चाहिए तब
Yes.
page 4 re hala, sir, the other case in which your lordship considered the petition of 8 accused persons and granted liberty to surrender and go in bail.
Page 4.
Page 4 and 5. So they were 8 persons. My application,
Your application Lakshmidhar Purida.
Lakshmidhar Purida was not there. I had come in a separate application.
Yes.
So on consideration of the injury report and statement, all that your lordship had considered this application. But maybe there could be something more than what it transpires now from the order. Your lordship says that nature of acquisition and the materials on record, I am not inclined to grant. So I am seeking that indulgence, your lordship.
What intelligence?
Because my lord, the allegations are same. We are in a group. Injuries are simple. So that
So other persons have been granted bail.
other persons, that is page 5, I am showing your lordship. I have filed the connected bail applications order. Having regard to the nature.
Page 5 of which application?
IRO, sir. Oh, sorry, I should have said that. Having regard to the nature of acquisition and the materials on record, I am not inclined to grant anticipation.
Well, I'll grant parity. Parity will do.
May I pray one thing, your lordship? Your lordship, the connecting bail, that is ABLAPL number 14782 of 2023, your lordship. Your lordship, that is order dated 24/1/2024. Your lordship specifically directed, and this is the omnibus allegation against specific the Lakshmidhar Purida, the present petitioner, lords. So may I pray, your lordship, kindly tag this bail application and let them solve the copy, my lord and senior. So let it come on Monday.
Simply modify our parity में लिख दिया जीवो. Maintaining parity, that's all.
Yeah, that order for once again, your lordship.
If you want any professional interest, then I can say that you have objected vehemently, fought tooth and nail, argued vociferously and whatnot. I can use many more adjectives. And ultimately, I'll say that the arguments are attractive, but without substance, I don't accept it.
In all the
ଗୋଟେ paragraph କହିବି ଯଦି
in
ଲେଖିଦେବି।
all the 8 persons,
ଆଉ କିଛି କରିବିନି।
they are all the women.
ଛାଡ଼।
That's why your lordship granted.
Considering the submissions, prayer for modification is allowed only to the extent of adding the following sentence at the end of paragraph 7. Further, look, the court below shall follow the principle of parity, since it is submitted that several co-accused persons have been released on bail. That's all. Or a court declared court search in the outer court. 46.
May I lordship, please? 46. May I lordship, I am coming from prisoner petition, my lord.
46:1. I am for the petitioner earlier, your lord. The petitioner never come forward, the petitioner is in, relatives never come forward with a, for me, for consent, your lord. And for a prisoner petition allegation against me for that reason. It is very unhealthy situation, your lord.
No allegation, my lord, only for delay, no allegation, only for delay. 6 months delay.
Delayed reason.
Only for delay lekha hai, petition ta thodi achi. Prisoner petition ta only for delay, ଆଉ କିଛି ଲେଖା ହେଇନି।
consent ଟା ନେଇଯିବାର କିଛି ଅସୁବିଧା ଥିଲା କି? consent ଟା ଦେଇ ନଥାନ୍ତି।
କରୁଥିବା ଓକିଲ ଶ୍ରୀ ଜଗନ୍ନାଥ ଭୂୟାଁ ସଠିକ ଭାବରେ ମୋ ମକଦ୍ଦମା ପରିଚାଳନା ନ କରୁଥିବା ହେତୁ
only for delay, ମାନେ 6 ମାସ ହେଲା delay ହେଲାରୁ ସେ
ମୁଁ ବୁଝିପାରିଲିନି ସଠିକ ଭାବରେ ମୋ ମକଦ୍ଦମା ପରିଚାଳନା
ୱାଟା ଲେଖା ହେଇଛି।
ଆଜ୍ଞା ମୁଁ ଟିକେ ପଢୁଛି।
my lord
kindly
my lord
give me that audience। ସଠିକ ଭାବରେ ଶ୍ରୀ ଜଗନ୍ନାଥ ଭୂୟାଁ ସଠିକ ଭାବରେ ମୋର ମକଦ୍ଦମା ପରିଚାଳନା ନ କରୁଥିବା ହେତୁ ମୁଁ ତାଙ୍କୁ ପରିବର୍ତ୍ତନ କରାଯାଉ କିଛି ନାହିଁ। The State Council is directed to is requested to cause an inquiry to be conducted by the sub-assistant jailer, Circle Jail Fulwani, as to under what circumstances the prisoner's petition was sent to this court, and what is the basis of the allegation made against Sri Jagannath Bhuya, learned counsel, previously engaged by him. The report of the jailer should reach this court
next week any date।
नहीं रोज नहीं ये तत्तरेला हुआ क्या टिके रहना देखे ये तो जेल ଅଛନ୍ତି ଭଲ ସୁରକ୍ଷିତ ଭାବରେ ଅଛନ୍ତି क्या ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ
ମୁଁ କହ ଆଇକୁଛି ମୋର କିଛି ଗୁଣ ନାହିଁ ମୁଁ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ
ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ ନାହିଁ ଆପଣ ମୋତେ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି ସେ ଜେଲ ଅଛନ୍ତି ସୁରକ୍ଷିତ ଭାବରେ ଅଛନ୍ତି
ମୋର କିଛି ପିଲାର କାଇଁ ଜେଲ ରହିଛି 4 ମାସ ପରେ ମୁଁ ଧରା ହେଇଛି
ଖାଦ୍ୟ ପେୟ ଦିଆ ହଉଛି କ୍ୟାଲୋରିକ ଇନଟେକ୍ ଟାକୁ ମେଣ୍ଟେନ କରାଯାଇକି ଦିଆ ହଉଛି ପ୍ରିଜନର
ଭଲ ଖାଇବା ଦିଆ ହଉଛି ହେଲେ
ହଁ ଭଲ ଖାଇବା ଦିଆ ହଉଛି
ମୁଁ ଏଗ୍ରି ଅଛି
ହଁ ସକାଳେ ଉପମା ଇତ୍ୟାଦି ସବୁ ଦିଆ ହଉଛି
my lord
yes to reach this court by 4th of August. Release this matter on 5th of August.
my lord
beg your pardon my lord
my lord
don't forget that you belong to this bar. And the person who is appearing from the other side, whatever may be the professional, he is saying that he would have readily given the consent. Why make an allegation against a lawyer and take the brief?
ସେମାନେ ମତେ ତ ଡାଇରେକ୍ଟ ଡାକି
ଭୁଲ ନାହିଁ ଆପଣଙ୍କର ଭୁଲ ନାହିଁ ଆପଣଙ୍କ କଥା କିଛି ଲେଖା ଅଛି
नो my lord
ସିଏ କହିବେନି କାହିଁ କୋଉ ବେସିସରେ ସେ ଆଲିଗେସନ କଲେ ବୋଲି
my lord
beg your pardon my lord a third case of this item my lord
Lordship, I will second the କହିଦିଏ
sir koi din
with leave of this honorable court my lord this
it's a disposal of matter.
Yes, pursuant to your lordship's direction, I was released interimly and I am submitting your before lordship the
Surrender certificate. All right.
in this my case my lord
ଟିକେ ଗୋଟେ ଯିବା ଗୋଟେ
second item.
If
And
we
you
have
are so
second item,
fortunate, my lord.
Learned counsel for the petitioner files surrender certificate in court, which shows that the petitioner has surrendered to custody on 27/6/2024. The surrender certificate be kept on record. Yes, the other matter, third matter.
Here, my lord, I'll take one line submission for your lordship's pious observation. He could see his father the same day the father passed out. Yes, ma'am.
hard case my lord
Lordship is nothing.
No, it's happens.
Yes,
Let us
hard case my lord my IN number 811 of 2024, the Lordship had extended the time for surrender, my lord, for 1 month. And the time has not expired, my lord.
Call it. Let it lie over. Let it lie over.
Enko sagar no asu, seta alga asu.
This matter has been tagged together as because they are
How,
going
the
well.
here?
They are
I'm not passing any adverse order against you, so why?
they are
Yes.
going on well. For that reason, this petition has been.
Yes. Item 47.
My lord, sorry, my lord.
Yeah.
Item 46, I will bring the instruction or your lordship?
No, you will bring rules.
Yes, ma'am.
On behalf of Mr. Rai, I may be permitted to.
Yes.
But here is the custody 2021.
Ramananda Swami.
12/2021. But it's a case of 498/304B/302. But may I pray, my lord?
Ramananda Swami was earlier rejected.
Again. But 3 ମାସ ଗୋଟେ entry
is
bill
going
past including informer 5 witness already examined. That is reflected in the my lord rejection order.
Rejection trial is going on smoothly.
Compressor. 20 chipping marching.
5ଟା factual ଖାଲି 2 ମାସ 2 ମାସ
Who are the witnesses who have been examined? If any material witness has not been examined, I will not grant it.
including informer you only come to page 14.
No, who are the main witnesses? I am asking you. Who are the main present material witnesses in
First
this?
time it has come. So,
You bring the case diary, I will consider.
case diary and so also we will supply the
Give
deposition
the
copies.
copies of depositions. Correct. Learned counsel for the petitioner shall produce the depositions of the witnesses examined so far. State counsel shall also produce the case diary. List this matter on what a week for
9th August.
9th August.
Item number 48.
Extended by the suffering from dengue. Para 4, my lord. My miscase.
Yes.
26 ସପ୍ତାହ ପୁରୀ ଯାଉଥିଲା ତ ଡେଙ୍ଗୁ ହେଇଛି ଆଗ ଥର ଯାଇଥିଲେ ସରେଣ୍ଡର କରିଥିଲା
Dengue. When is the release date? When is the surrender date?
26/6/7
মানে আজি 26/7. A prayer for extension of interim bail is made on the ground that the petitioner is suffering from dengue. Such being the submission, the period of interim bail is extended by 2 weeks.
1 month.
4 weeks could be.
Item 49.
May I please, Your Lordship? In this case, the present petitioner has been earlier released on bail by this honorable court. And after that, he was arrested in another case. So during the time of appearance, he could not appear in the court because he was in custody of. So NBW was issued and executed while he is in custody.
Yes.
It's a case of Belgium. Initially, in the present case, Your Lordship granted 260 grams of brown sugar, Your Lordship granted. And again, he has committed the similar type of offense and taken into custody. So,
Brown sugar?
Yes, my lord. Brown sugar. Apart from those 2 cases, one brown sugar, 152A BR cases there for antecedents.
My lord, in that case, the brown sugar has
Not been seized from him, but he was there, 18 grams. He was released on bail, but 21C brown sugar and another brown sugar and 52A BR.
No.
For criminal.
No. The petitioner was earlier released on bail as per order passed by this court in BLAPL number 2008 of 2022 with certain conditions. Stop. Since he did not appear before the court below, NBW was issued on the strength of which he was again taken to custody. Stop. It is submitted that the petitioner could not appear before the court on the date fixed as he was apprehended in connection with another case. Then State Counsel opposes the prayer for bail by submitting that the petitioner was found to have been involved in a case involving similar offense. This shows the conduct of the petitioner. And that he is a habitual offender. Under such circumstances, I am not inclined to allow the prayer for bail. Stop the bail application is therefore rejected. Yes.
Item 50.
53 is it?
I have prayed for extension.
Yes, Mr. Pradhan.
Yeah, I have prayed for extension on the ground. If you also kindly see page 9. Angiogram was conducted on page 10. Thereafter, the Ames Hospital advised for cardiac MRI. Data has been fixed to 16/8. That's why I pray, Lord, another 4 weeks.
Considering these submissions and the fact that the petitioner is required to undergo MRI,
Wife will go MRI.
petitioner's wife is required to undergo MRI, I am inclined to take a lenient view. The interim bail granted by order dated such and such
26/6.
is extended by a further period of 4 weeks.
51 also same.
Yes. 51?
51 also same. Dita order again.
All right, same.
Another case, but setre na gale
How natural.
item 52.
The alleged offense, my lord, 498, 323, 294, 312, 5, 494, 307 IPC. The matter is comprised between the husband and wife. They are maintaining happy conjugal life. The informant also appear. So independent advocate and file affidavit. They are missing those. Honorable Court of injury report, but no injury. Injury kichhi nahi.
This is the third consecutive application, my lord. First one rejected.
Metro is a compromise.
Second one, my lord, early rejected by this court on merit. So
I rejected it on the ground that ଖଟରେ ବାନ୍ଧିକି ରଖିଲେ ଏବଂ ତାଙ୍କର ପେଟକୁ ଗୋଇଠା ମାରିଲେ ଯେତେବେଳେ when she was pregnant.
yes.
I will not indulge.
ମାନେ ଗୋଟେ ବର୍ତ୍ତମାନ ସେଟଲ ୱାଇଫ ବି ଆସିକିରି affidavit ମିଶିକି ରହୁଛନ୍ତି.
So settlement in a 307 matter.
Husband wife is matrimonial Supreme
You
Court.
do one thing. You initiate a case against the informant. Initiate a case against the informant.
ମାନେ ସେ ଯେ mother of 3 children.
ଆପଣଙ୍କୁ କିଛି କହିବାର ନାହିଁ ଏଥିରେ.
ନାଇଁ ସେ ମାନେ ସେ mother of 3 children. ଆଉ ବାହାଘର ବି ବହୁତ ପୁରୁଣା.
No.
ଏହା due to enemy for the law. Now the matter is
Mr. Sonami, it's a very simple କଥା. Sessions case settlement ହେଇଯିବ ଆପଣଙ୍କ ଭିତରେ. ଏଠି ତ କୋର୍ଟ ବସିଛନ୍ତି ଗୋଟେ ଇଏ ଆଉ.
Till date, no charge sheet filed.
Making a mockery of this system.
Honorable Court last date confer करते injury zero my lord.
I will not grant bail.
My lord injury मांगे थे.
I will not grant bail.
My lord instruction आनी वो उधर मिसी गलनी सांगा ही रही रहनी.
No.
Out of date आसु मानी.
No. Out date आसु मन परिवर्तन होली होचंती. किछि मन परिवर्तन होली.
अरे मन परिवर्तन मिसी सांगा ही रहली.
No. Don't say that, sir. Don't say.
Out of next week आसु.
Don't say that and this affidavit this so कौन है? Sessions case affidavit.
नहीं वाइफ
Your lordship ବର୍ତ୍ତମାନ ସେ କେୟାର ନେବାର ଆରମ୍ଭ କଲେଣି.
So 307 matter can be settled.
307 made out ହବନି ତ.
So you had lodged a false FIR. So you had lodged a false FIR.
ସେତେବେଳେ ସମୟରେ
Why should action not be taken against you under section 193 of the IPC?
somehow with a helplessly
Sir, tell me. We understand, sir. I've been a sessions
sir 2 because
sir, I've been a sessions judge, so I understand what happens in the ground reality.
मैंने हमें annexer 2 करचो running page 11. Doctor will let normal delivery is 2015.
No.
এটা 50 মସିହା କଥା.
No, injury is not.
Injury no.
A person who can misbehave with his wife like this.
ସେ ବି ଡକ୍ଟର ଲେଖିଛି ନର୍ମାଲ ଡେଲିଭରି ହେଇଛି. Annexure 2 my lord running page 11 ଡକ୍ଟର ସେ ନର୍ମାଲ ଡେଲିଭରି ହେଇଛି.
ଯେତେ ଆର୍ଗୁମେଣ୍ଟ କରିବା କଥା କର. ମୁଁ ଶୁଣିବାକୁ ରାଜି.
ଆସୁ my lord ଗୋଟେ next week husband wife case my lord. ଛୋଟ ପିଲାଟା ବଡ ବଡ. He is a mother of 3 children.
No.
Mother of 3 children.
No, I will reject your application now, right now.
କହିବୁ ତାଙ୍କୁ କହିଛୁ 2 ଜଣ ଆସିଥିଲେ ତ ବାହାରେ ଅଛନ୍ତି.
Sir, I don't understand. You are a senior man now. Mr. Sonny, what kind of submission are you making? ଆପଣ ଆରମ୍ଭ କଲେ କହିକି ଯେ ମ୍ୟାଟରଟା ସେଟଲ୍ ହେଇଯାଇଛି. And you are referring to an affidavit in a 307 case.
Personal appearance.
Why personal appearance? How will that have a bearing on the court? It's a non-compoundable offense. It's a sessions offense. How can the court compound it?
First or second or
nothing. You withdraw it, you may move the court below.
Next week also instruction
No.
husband.
No. I'll reject it right now. the petitioner.
My submission, my lord. ଖାଲି ଆସିଛନ୍ତି ତ ଗୋଟେ ଡେଟ୍ ଦିଆଯାଉ ମୁଁ ତାକୁ ଟିକେ ବୁଝେଇ ଦିଏ ହଜବେଣ୍ଡ ୱାଇଫ୍ କେସ୍ କଣ କିଛି ଅଛି ନୋ
Place this matter next week as paid for. Yes.
Item 54.
increment
53 to Mala. Withdrawal.
increment
To continue. Yes. 54.
Item 54.
The similar order passed has been passed by the my lordship in 7349 of 2024 and on dated 25/7/2024. Same day disposal parity could be maintained. That order.
Yes.
Yes, it was there, my lord. First or second or same day is there, my lord.
All right.
Parity is there, my lordship.
All right.
Item 55.
Obliged.
Petitioner is the wife of the main accused. The lawsuit passed this order in relation to his husband. The same order is kindly passed.
This is for modification.
That is owing out of the conditions. He is the main accused, sir. But he is the wife. This is the wife and his abet.
You can pass similar order. Yes, Mr. Mishra.
My lord.
You can pass
Vigilance.
similar.
Vigilance.
Vigilance. Yes, Mr. Das.
I am appearing on behalf of vigilance, my lord.
So we'll pass similar order, Mr. Das.
As your lordship deems fit and proper.
Same order. Pass order actually.
So item number 36.
May I pray free copy be granted?
Free copy of the order be handed over to Sri Sanjay Kumar Das. Item 36.
And for the opposite.
Yes, none appears for the petitioner on repeated calls. Yesterday also, there was no appearance from the side of the petitioner.
Yes, my lord, it is not yesterday.
On the last occasion, that is 19/7/2024. Also, there was no appearance from the side of the petitioner, despite repeated calls. As such, it is presumed that the petitioner is no longer interested to pursue the transfer application, which is therefore dismissed for non-prosecution.
Interim order is vacant.
Interim order.
Nice, sir. Holds go to
The interim orders stand vacated.
So item number 39.
weekly bites that.
39.
Yes.
Bail letter what কোন আসছে?
Status report was called.
Letter of the court below reveals that 4 out of 16 witnesses, 4 out of 16 CS witnesses have been examined so far. None appears for the petitioner. List this matter 1 week after.
Item 40.
Extension. Four months time is allowed to the court below for disposal of the case.
So item number 42. And
কি তো না দি
Last occasion also no.
What about you were directed to apprise the court about the status of NBW.
NBW has not been issued. Neither surrender, he has surrendered.
None appears for the petitioner on repeated calls to move the IA. Sri Anil Kumar Naik, Learned Counsel appearing for the OPID submits that the NBW has not been executed as yet. In such view of the matter, IA dispose of him though?
Similar,
তাহলে কিছু করার নেই।
এটা কিছু করিয়ার নেই।
So the matter be delisted or? Yes.
It can be dismissed as,
Oh, though it has not been dismissed.
no. For non-appearance, because the Supreme Court, letter from Supreme Court has come.
Where is that
I
letter?
have not seen that letter. Probably has moved the apex court.
See, लिख लीजिए, to enable the petitioner to deposit sum of rupees 15 lakhs with the trial court list on 26/4. If evidence of deposit of rupees 15 lakhs is not furnished by that date, the petitioner is liable to dismiss without further reference. You please take instructions on this. Automatically dismiss it. As the petitioner has not furnished proof of deposit of rupees 15 lakhs as directed by this court, the special leave petitions are dismissed automatically.
That is the order dated.
26/4/2024. You go through these. File that you go through and then make your submission. Let's this matter next week. 1st August. You go through those orders of the Supreme Court so that you will be in a better position to make your submission. Yes. Hala.
We can still in time.
Weekly list item number 24.
I am asking for the respondent to Mr. Senior Advocate A. Sudhakar Raman. So matter listed the last 5/7/2024 and the appellant is not attend this honorable court. In this last week also say, ma'am, this week they are not
Oh, okay.
after obtaining the stay order, they could not attend the honorable court.
None appears for the appellant. This matter being in the weekly list was called out throughout the week, commencing from 22nd July till today. It therefore appears that it is therefore presumed that the appellant is no longer interested to pursue the appeal, which is therefore dismissed for non-prosecution.
Second appeal dismissed.
Second appeal dismissed.
Item number 43.
43 कौन hearing? क्या अर्थ आरोपी के लिए थिला? अच्छा. None appears for the appellant on repeated calls. List this matter on in the week commencing 5th August. Yes.
Item number 48.
48. None appears on repeated calls. List this matter in the week commencing 12th August.